I pledge my eternal gratitude to any law nerd who would edit and combine original Emily's live coverage of this trial with Sidebars coverage at specific moments. That sounds like a doctoral project. Good morning, amazing law nerds. We are resuming in court. I should just call us, I feel like I should start calling us to session. Like I've got my gavel. Law nerds, all rise and come to order. Head law nerd Emily D. Baker presiding over the legal commentary / lawyer reacts / legal analysis of the Johnny Depp and Amber Heard trial. Amber Heard is on cross-examination. You are all in court this morning. Thank you for reminding yourselves that we are in court. This is May 17th, 2022, trial day 18. We're going to start there. The court, all right, do we have any preliminary matters before we bring the jury? It says bring in the jury, but whatever. Of course we do. Sidebar. Breda Hoft. These are all from the audio clips. The court, okay, the audio clips. Ms. Breda Hoft. And these are the redacted set of the 700. I think it's 717. The court, the redacted ones, Breda Hoft. And then I would like to revisit the issue, Your Honor. Your Honor may recall, and I have a copy of yesterday's transcript, and I tagged the section that's relevant here. So Your Honor may recall, first of all, I did put Ms. Heard on the stand, and we have that. At 134, she gives the foundation, explains how she put the metadata on there. So we covered that in the direct with regard to the metadata and whether it was redacted or not off a photo that was being shown during testimony. Then Ms. Vasquez says, and this is at page 134, quote, Your Honor, I would just ask the picture be redacted on hearsay grounds. And Your Honor granted that at that point. The court said, Elaine says, then I came back and revisited this. I tried giving the case law that said the metadata was not hearsay, and Your Honor believed at the time there was a foundation issue, but the foundation had been laid. And we don't have an expert that's going to say how she put the metadata on. In fact, we believe that we should be able to get those in on the foundation / hearsay. If they challenge the legitimacy, then in rebuttal, we have an expert to say those are legitimate photos. Other way, wrong order. But I need to get those in through her. If they challenge the legitimacy, which they already have, then in rebuttal, we have an expert to say those are legitimate photos. But is the metadata legitimate? It doesn't matter if it's a photo of Amber Heard's face. They're trying to redact the metadata, Elaine. But I need to get those in through her. Well, the photos are in. It's the metadata that's not in. And I believe that I've laid the foundation. Well, the court disagrees. And the only objection is hearsay. No, they objected to foundation too. And I think the case law is quite strong. The court, okay. Ms. Vasquez, I think this is an expert issue, Your Honor, as you indicated. The court, she's saying it's not hearsay, Ms. Vasquez, but there was no foundation laid for how that text got on the photographs. That's not a photograph. It's a photograph of a photograph. Ms. Breda Hoft, she explained, the court, I'm still going to sustain at this time, okay? On foundation and hearsay, all right? Thank you. Ms. Myers, we do have one other issue. The court, yes. Ms. Myers, so after our late day 2 weeks ago when we went over all the depositions, the court, deposition day. I can hear Judge A being like, deposition day. Ms. Myers says the parties agreed on their depositions. They were sent to be spliced. And then after they started coming back, they started unilaterally de-designating additional testimony. We've objected. What we agreed on in court and what was ruled on by the court is what the court said, right? Ms. Myers, we must, the court said, abide by. Ms. Myers said, we agreed that we would withdraw materials, but that was sort of when we were in court, had the opportunity to see what they were withdrawing, we could reevaluate our own designations we were withdrawing. So we would unilaterally designate after the depositions come back, depending on how long they are, because the court said, okay. Ms. Bredehoff said, so they de-designated back with Filati, and Your Honor said about whether you can cut back after Brandon Peterson and establish the two and the hows all the way through every single Friday. When we were in and out in the hallway, we both agreed that we could de-designate more later. It's just our designations. Yes, Your Honor, when Your Honor cut us back to 61 hours, we were in huge trouble. Oh, we'll talk about designations later if we even need to. What's more interesting is that they are very flustered about time already, and I'm not surprised. When Your Honor cut us back to 61 hours, we were in huge trouble and we needed to cut a lot of testimony, and that's what we did. And from May 1st through May 10th, we were sending them exactly the same way they did. We would send them to Planet Depots saying, please remove these. These are our designations, not theirs. And they had the right to de-designate more if they wanted to. No, they didn't say a word. From May 1st to May 10th, didn't say a word. So now we're having to figure out, or the team Depp is having to figure out what Team Heard cut out. Because at some point, if Team Heard is leaving in certain testimony, Team Depp might be like, yeah, it's fine. But then if Team Heard takes that testimony out, Team Depp might be like, no, we need that testimony back in. We don't want you taking it out. And then Friday night, they say, oh, we object to you unilaterally de-designating. We had already gotten new Splice videos now. They've got the same ones we do. They know exactly what we de-designated. I said, how are you prejudiced by this? It's what we designated. We need to cut because we can't get it all in. We had to cut. We had to cut significantly because otherwise we couldn't get our testimony in with Your Honor's time limitations. Your Honor, the time. The clock was a bigger factor in this trial. That's what's so interesting to me about this argument. The clock is such a big issue in this trial. We knew that watching the trial, but we see that even more now. Is that why Kate Moss didn't have a cross-examination? Exactly why. The clock became a huge issue. It was an issue for Team Depp as well, but a bigger issue for Team Heard. And you saw how flustered in closing Elaine was particularly. I don't think Rottenborn seemed as flustered until the phone alerts all went off. But you could see how flustered Elaine was with their timing issue by the time they got to closing arguments. The clock was a huge, huge issue here, but they knew. They knew going in. Jessica Meyer says, Your Honor, with respect to Ms. Filati's deposition, that one was ours that we did early on. And Heard's counsel reached out to us and said, would you agree that we can both de-designate further? In that instance, we said, yes, we agree. We both de-designated. We both told each other what was being de-designated and what we respliced. So took out and respliced. What happens with the ones that we handled 2 Fridays ago? We were exchanging emails saying we're going to de-designate this from the deposition and, vice versa. We came in, we worked through those. The court said, right. So they had a process. We worked through it, and then those were finalized in our view, unless we had an agreement that, we might, to spare our time, we could de-designate further than that. None of the ones that they are sending fall into that category. This is largely unfair. When we were doing the deposition videos in our case in chief, we didn't have the opportunity to ask after, hold on, we need to remove parts of it. They're taking advantage. So Team Depp is not happy the way that Team Heard is cutting some of the depositions. They were in court on Fridays cutting these depositions by agreement. What can come in and what couldn't come in. Bredehoff says that's just not true. So Jessica Myers is saying they feel that Team Heard is taking advantage. Bredehoff said that's just not true. They did it with Filati in the first week, Your Honor. They're not prejudiced. They're not prejudiced by this. This is our testimony. It's like us deciding not to ask the witness certain things. Yeah, but it's not like that though, Elaine, because if you decide not to ask a live witness certain questions, the defense or the other side can ask them in cross-examination. When it's a deposition, there's no chance to ask other questions because you've agreed on it in advance. They're not prejudiced by this. This is our testimony. It's like us deciding not to ask witnesses certain things, and we've been sending to them for 2 full weeks, and we were sending them to them saying, we're de-designating these. You're welcome to de-designate as well. Let us know if you have any issues with what we're doing. Otherwise, we're severely prejudiced, Your Honor. We can't fit it all in. That's the bottom line here. That's what we've done, and we've done it all the way through. The court said, but 2 Fridays ago, you knew we had 61 hours. And Bradahoff said, correct, Your Honor, which is when, 2 Fridays ago, we started de-designating, so pulling the testimony. When Your Honor said that, we said, oh my God, we can't fit these all in. We started de-designating. Ms. Myers, the court, 3 Fridays ago, Bradahoff said, we've been de-designating since that time. We've been cutting and they've been cutting. And every Friday, every single one of these lawyers here said, we're going to have to cut more. And they said, we will too. And I said, great. Just let us know. That's what we did. We let them know, and we let Planet Depots know we're beyond severely prejudiced because we're not allowed to cut our own designations. We didn't cut theirs. We didn't touch theirs. The court said, so how are you prejudiced by Ms. Myers, who's one of Depp's attorneys, said, so Your Honor, we are not objecting to what was withdrawn 3 Fridays ago. The court said, how are you prejudiced if they cut more now? Jessica Myers said, the issue is what we removed or what we agreed to remove or lock in was based off our understanding of what their designations. And then it looks like Ms. Vasquez jumped in and said, and Your Honor, and Mr. Chu jumped in and said, we knew the limits. And Ms. Bradahoff said, we said, if there's any specific ones you have, let us know. They never did that. We've been doing this for 2 weeks, Your Honor. Vasquez said, Your Honor, if I may, wait, why did we all cut off Jessica Myers? What happened? Why did Jessica Myers just get stepped over? Ms. Vasquez said, Your Honor, if I may, you would really, to do this to us when we're trying to prepare for cross-examination and take away attorney resources, they have decided after Your Honor has ruled on these depositions to de-designate further, not in agreement with us. It's not fair. Mr. Rottenborn, they had a 10-day break to prepare for cross-examination. Ms. Bradahoff, Your Honor, there's no prejudice to them. Ms. Vasquez, there is. Ben Chu, there is. Ms. Bradahoff, give us one designation that we de-designated that somehow that's their prejudice. This is our testimony, Your Honor. Oh my God. Then Jessica Myers jumped in. After we were in court 3 Fridays ago and you marked up our transcripts, we have not sent any further de-designations. They're still fighting over all of this testimony. Here's the fight. That they're all just like, it's not fair. It is fair. It's fine. No, it's not. Here's the problem. When they were cutting down these depositions, what Team Heard or Team Depp agreed to was in context of what was already agreed to. So we believe that this testimony is coming in, so we're okay with that testimony not coming in. But when they start pulling out that testimony, it's like, wait a second, we all agreed on what was getting cut out of these depositions, and now we can't agree because we need to go back and do this or that. Ms. Bradahoff said, Your Honor, actually, I don't agree that we knew from the very beginning. I know Your Honor said in the first week, Ms. Myers said they've received some videos back and then they saw the time and then they started slicing more. Ms. Bradahoff said, exactly, we had to because we can't get our case in. We would be severely prejudiced by that. The court said, but you knew from the very beginning. You knew the time. Ms. Bradahoff said, Your Honor, actually, I didn't agree. I don't agree that we knew from the very beginning. I know Your Honor said it in the first week. The court, right. Ms. Bradahoff, we're going to 72 hours. And then Your Honor changed that down to 61. This is our case now. And once we got the time, and in fact, we have suffered a lot. So it looks like the court cut 11 hours. That's a big, big cut I wonder what happened that the court cut that. No wonder Elaine is frantic about this. But they're all saying all parties knew this in the first week. Remember the Brandon Patterson one, because they wouldn't agree to the authenticity of all those video clips. We had 2 hours and 49 minutes of authenticating each of those. And then they agreed to it just as we were coming in for that. So we've got stuff for 2 hours and 49 minutes. When we got the time estimates, Your Honor, we came back and said, we can't do that. We have to cut. And we did cuts. I'm not hearing any prejudice on our cuts, Your Honor. This isn't any prejudice. It's not like us not asking more questions. And we've said specifically, and we've been doing this for 2 weeks, Your Honor, they didn't say a word until Friday night. And it sounds like that's when the videos came back. And we said, you're welcome to de-designate as well. And if you have any issues with any of our designations, but we cannot get our case on if we use the originals, we had to cut. The court said, I can't require her to use the originals that you based on just because you're doing this all by depositions. It's just a very strange case, but it's their case, their testimony. So I'll allow the de-designations. Let's move on. This is the beginning of the full day of cross-examination of Amber Heard. If this cross only goes half a day today, we're going to zoom through the rest of it. Boys, you can't fight with each other in the window. Stop it. The wild Fred and the wild George are just having a moment. And then,
all right, are we ready for the jury?
Good morning, Ms. Heard.
Thank you for pointing out. There's LawTube.
Directing your attention, Ms. Heard, to the page 14.
Oh my God, Tuman, we're all stuck on the big knife. I mean, it's big, huge. And to be like flippantly say, I didn't think he was going to stab me with it, just flies against everything she's trying to establish she has. You have PTSD from being abused, and this is the present.
And your signature appears right under the statement, quote,
feels like
I declare under penalty of perjury, under the laws of the state of Virginia, that the foregoing is true and correct.
That is correct.
And this is dated April 10th, 2019.
Correct.
Now let's look at paragraph 16, which is on page 5, specifically line 10.
The hard part about being a female attorney is that I think they probably have to get up at least an hour earlier than their men.
Right. Testify under oath.
Counterparts.
While he was smashing the phone, Johnny severely injured his finger, cutting off the top of it, end quote. Did I read that correctly?
Yes, that's correct.
So that was your testimony then.
So you testified in this courtroom that after Mr. Depp smashed the phone, he held you down on the countertop by the neck. Do you remember that?
I'm not quite sure of the exact sequence of things, but yes, both of those things happened.
Convenient.
We'll get to the sequence.
Sure,
and this is when Mr. Depp supposedly assaulted you with a bottle, right?
On the countertop, he assaulted me.
So Mr. Depp was able to get you on the counter, right?
He held me down by my neck.
And hold you down by your neck.
Did he lift you by your neck?
Correct.
And he grabbed a bottle, according to you, while holding you down by the neck, correct?
I'm sorry, can you clarify what you're asking me?
She's asking you
while
how the
Mr.
fuck this
Depp
happened.
Is holding you by the neck against the countertop.
In order.
He grabs a bottle. That's your testimony.
No, those two things didn't happen at the exact same time, no.
Oh.
While he's holding the bottle, is that your testimony? While holding you down by the neck?
Sorry. What was your question?
Your testimony is, Ms. Heard, that either he has the bottle before or after.
Camille has to make sure she doesn't get angry.
Is that your testimony?
He held me by the neck on the counter.
And then?
Where's the bottle? That he assaulted
At what point?
Right then.
While holding you down by your neck.
We're going to go step by
step.
step.
When he was assaulting me with the bottle, it was in his hand.
No.
Was it
that
in
wasn't
his
the question.
Hand before or after he holds you down by your neck?
I was being held down while he assaulted me with the bottle.
How did you get there?
When he puts you on the counter, does he have the bottle in his hand? Yes or no?
She doesn't know.
As I have always said, I don't remember exactly what happened first, or I don't remember the sequence. I just remember being aware that I was being assaulted by a bottle while I was on the countertop.
So he penetrates you with this bottle. But you don't know how he got the bottle, right?
That is correct.
Camille's
and he did that right after he lost the tip of his right middle finger.
Again, I don't remember the exact sequence of those events.
We'll get to the sequence. And while he was on 8 to 10 MDMA pills, right?
Yes.
Just preposterous.
Let's talk about the sequence.
Yeah, let's.
This is the sequence of events you testified to in this courtroom. that he smashed the phone to smithereens and then assaulted you, lost the tip of his finger, and then assaulted you with a bottle. Yes, that's the sequence of events that you testified to in this courtroom.
To be clear, you're putting it in order when you say words like then. I have never claimed that I can remember the exact sequence of these things. This was a multi-day assault that took place over 3 horrible days.
Ms.
It's
Heard,
the worst thing ever
Ms.
happened
Heard,
to me. I
we're
don't
not-
remember
Ms.
the
Heard,
exact
That's not
Objection
my
non-responsive.
My question isn't about the 3-day assault allegedly that occurred. I'm just talking about the sexual assault that you now allege occurred.
Yes,
Okay.
correct.
The nice thing is
Let's
to
look
be
at the
able to be
transcript.
pleasant in
So
those
you testified
moments.
on page, I'm getting there, 4506. Okay. And the reason that we need to go through this, Ms. Heard, is because we understand that these are very serious allegations that you're making, right?
It was horrible. What happened to me? Yes.
Okay, so let's go through them. So you're acknowledging by this sequence, not my words, your words, Ms. Heard, that you testified to this jury that Mr. Depp smashed the phone to smithereens before he assaulted you. That's the sequencing in which you testified, correct?
I have never testified to a sequence.
But you did. This is why this matters.
Talking about that sequence.
They're
then on
getting
page
to the
4521,
headline of the digital print
starting
article.
at line 3,
Because the headline is
you
their
testified to
strongest
being
case
bent
for
over backwards
defamation.
on the bar, right?
Okay. Can we approach? We don't like going through this line by line with our client. This is going to be a mess. Ms. Bredehoff, Your Honor, may we approach the court? Okay, sidebar. Ms. Bredehoff, the question Ms. Vasquez is asking is not proper impeachment to use. Impeachment means using testimony in this context, using testimony from a different time to show that the person testified differently. So you're impeaching them with their prior testimony. Okay, so this time you said this and last time you said this. And Elaine's objecting. Elaine said Ms. Vasquez is asking is not a proper impeachment to use. She needs to ask the question and then go to the page and the line and read what was testified to the page. Instead, what she's doing is she's characterizing her interpretation of the testimony. She keeps inserting her own language. That's not proper impeachment. She has to ask the question that's asked here and give a different answer and then go back and impeach her. That's what she's doing. Ms. Vasquez, I'm not impeaching her, first and foremost. Elaine actually laid out the process for impeachment quite well. Thank you, Elaine. She understands the process for impeachment. And Ms. Vasquez is like, that's not what's happening. Ms. Bredehoff said, Ms. Vasquez said, Ms. Bredehoff, I'm not impeaching her. This is the statement of the party opponent. I can use them however I want, and I'm entitled to do that. So we're going through the transcript. These are misheard statements under oath, and I'm using them the way I see fit. Ms. Bredehoff said she's testifying to her own characterizations of what Ms. Heard is testifying to. Okay, first of all, Elaine, what's really funny is that she's now like, no, there's a proper process for impeachment. But when Elaine's doing something, she's like, Your Honor, isn't it just fine? And Camille is like, that's not how any of this works. I'm not impeaching her. These are statements of a party opponent. I'm allowed to bring them in. And Ms. Bredehoff's like, she's testifying to her own characterizations. Elaine, it's cross-examination where the question is the point, and it's exactly what Elaine did on cross-examination. So it's just, she's used the word sequence. I can't tell how many times. There's no word sequence in here, Your Honor. The court, you can ask the questions and you can use, I understand, you can ask the question, just don't comment on the answer. Ms. Vasquez, okay. I mean, it's cross-examination. The court, I would appreciate that. Ms. Vasquez, okay, thank you, Your Honor. You want to talk about somebody commenting on the answers, Elaine? That's literally your entire process of questioning. Your entire process of questioning is giving commentary to the thing you just asked. But all right.
That's what actually happened in Australia, isn't it, Ms. Heard?
I was there.
So that's
I remember it. I knocked on one bathroom door. I came on the first night after he decided to take the bag of MDMA.
Ms.
And I
Heard,
went to check
Ms.
on him
Heard,
and see
I'm going to
if we
move to
could-
strike everything after I knocked on
Objection,
one
move to
bathroom
strike,
door.
non-responsive. It's not responsive.
Not quite, so I will sustain the objection. Just answer the question, okay, ma'am?
Oh, she's using the judge.
The recording we just
To
listened to.
reset.
That's exactly what happened in Australia. Mr. Depp lost the tip of his finger after you threw a bottle at him. Isn't that right?
That is incorrect.
She couldn't admit
You
it.
can scroll down.
The reason this cross is so powerful is
No.
because it doesn't matter what the answer
Ms.
is.
Butterhoff, if you don't have your microphone on, I cannot hear you.
Ms. Bredehoff, get it together,
You
Elaine.
still don't have it on.
Elaine.
I need to take a look at the unredacted for a minute, Your Honor. Just bear with me.
All right.
I'm not admitting it into evidence yet. I would like to just
Okay.
talk to
yes,
the
okay.
witness about it
Go
if I
ahead.
could. Thank you, Your Honor.
Stop wrecking my flow, Elaine.
Ms. Heard, I'm going to show you what's been marked as Defendant's Exhibit 371. Do you recognize these text messages between you and Dr. Cowan?
I don't recognize these, no.
Who's Dr. Cowan?
He was my therapist that was recommended to me from Dr. Kipper. He and Dr. Kipper worked together.
He was your therapist at the time, correct?
That's correct.
And you had been seeing him for almost a year in March of 2015?
I know, right? She can't turn on the microphone.
My guess would be about 6 months at that point.
Elaine is shook at this point. She can't even push the button on her mic. She can't find the button.
Your text messages are in gray, correct?
Your Honor, I'm going to ask that she show her the unredacted so that she can see the text exchange back
All
and
right,
forth
if you
if
can-
she wants to
That's
talk
fair.
about
All right, we'll
moving
pull that up.
unredacted
Sure.
later.
That's
Go ahead.
fair.
Pull it up.
That's fair. It sounds like you got your mic on, Elaine. Well done. It was a problem all day yesterday. Can you imagine being on a Zoom call with Elaine? Elaine, you're muted. Elaine, you're still muted. Turn on your mic, Elaine.
Seeing these unredacted messages, does this refresh your recollection that these are indeed communications between you and Dr. Cowan?
Yes, that's correct.
Doctor, your text messages are in gray, correct?
Yes, that's correct.
And Dr. Cowan's are in blue?
That is correct.
Do you see the text message at the bottom of the page from March 8th, 2015 at 8:29 p.m.?
Robin
Yes,
Runkle
that's
did
correct.
not get in.
March 8th is the day that you were allegedly sexually assaulted by Mr. Depp in Australia, correct?
That is correct.
So on March 8th, 2015, you were in Australia
That is correct.
and Mr. Depp's finger had just been cut off, right?
That is correct.
And you write to Dr. Cowan, quote, "I feel so lost. I can't talk. I don't know if I'll ever be able to change." End quote.
Oh,
Did I read that correctly?
That's correct.
You weren't able to change, were you, Ms. Heard?
I very much wanted to leave the relationship I was in, but I didn't have the power. I didn't feel I had the power to leave. I knew I was in a very toxic relationship with Johnny, and I knew I needed to change that. I knew it was, at this
that's
point,
true.
horrible for me. And I
I'm gonna
talked to
move
my
to
therapist
admit-
often about that.
Exhibit,
Oh, shit.
Defendant's Exhibit 371 as redacted with just Ms. Heard's messages.
That
All right.
text
Your Honor, I object
echoes.
because she has left out the next two lines from Ms. Heard that clarify even further, and I also
You don't need
think
to clarify.
Dr.
Bredehoff,
Cowan.
Miss Bredehoff.
Your Honor, may
should
we
be-
please
let's-
approach?
let's-
Elaine. Bredehoff, Your Honor, I object because she has left out the next two lines from Ms. Heard that clarify even further. And I also think, Ms. Vasquez, Ms. Bredehoff, may we please approach with this? Because Ms. Bredehoff is now giving an argument in front of the jury. Sidebar. Ms. Vasquez, I'm going to ask, Your Honor, that Ms. Bredehoff, the court, I just need, what's your legal objection, Ms. Bredehoff? I can't have talking objections. Ms. Bredehoff, I'm sorry. I think if you look at the redacted, the court, you're saying they redacted more of her statements. Ms. Bredehoff, yes, they did not. She's got more in here. What is the legal grounds, Elaine? Not just like, I'm mad you redacted it. What is the legal grounds? Is this completeness? What is happening? Yes, they did not. She's got more in here. Right. Ms. Bredehoff, that gives the context of this. Oh, complete. You're trying to argue completeness. They're trying to take it out of context and just put these three in. Right after that, she has two more, but she also has the ones before that and the ones that have Dr. Cohen responding to it. Ms. Vasquez, Your Honor, she's able to, the court, but this is their evidence. This is not Ms. Bredehoff. Ms. Bredehoff, when we were objecting, when it was in their case in chief, they were able to put context in, Your Honor. The court, you didn't object to having in the context. You didn't object to them having the context. Oh, Elaine. The court's like, they got to do it. And the court's like, you didn't object. If you object, I can rule on it. And Ms. Bredehoff goes, actually, we did. The court, no, you did not. Ooh. Yeah. Ms. Vasquez, Your Honor, hey, Camille, don't pipe in at this point. Let them fight. Nope, let them out. Camille, let them fight. No, at that point, until they're done, you're just real hard to do in the moment, though. It's real hard to sit down and shut the fuck up in the moment because she's still trying to finish the sidebar. But when the court and Elaine are going at it, it's just like, the court, do you have any objection to the context coming in? Ms. Vasquez, it's our evidence. We would just like the text messages that I read into the record that Ms. Hurd has testified to are her texts. That's it. I'm trying to make this as easy as possible for the court and Ms. Bredehoff by redacting the hearsay, trying to be respectful of the court's time and the jury's time. And she is purposely interrupting the flow of this examination, and she's making argument. Oh, Camille's pissed. It did feel like Elaine was trying to trip up the cross-examination. However, that is also a valid strategy. That's exactly what Elaine was doing. But also that's not improper. So if you have a valid legal objection, the making argument to the jury in the middle of cross-examination, that part's improper. The court says she's got a valid objection. That's fine. Ms. Bredehoff, the next two are the same part of that. Same one, Your Honor. She's saying, Ms. Vasquez, clearly I can't, Ms. Bredehoff. Ms. Bredehoff, she wants to keep that out, but that's part of the exact same text exchange. The court, on direct, redirect. If you want to put that in there, I don't know if that adds to your case, but if you want to put that in on redirect, you can redirect on it. Okay? Ms. Bredehoff, thank you, Your Honor. Back to court. Oh my. Elaine wants completeness. That's what she is trying to ask for. She's not asking for it well, but she's trying to ask for completeness. Elaine can complete that in her own exhibit, though, on redirect. So with this, it's very interesting to me that what we're getting is the you aren't scared of him. She never admitted that she was scared of Johnny Depp. She said that she had a mixed relationship with him and that things he did were scary, but she look at the judge's body language. Elaine, the rules of evidence are simple and finite. It's not even a very big book. Anyway, that she never could admit that she is afraid of Johnny Depp. And that is staggering. It absolutely supports Dr. Curry's testimony and goes against everything Dr. Hughes testified to. I want to see
so
the
you
text.
write, Ms. Hurd, to Dr. Cowan, I feel so lost. I can't talk. I don't know if I'll ever be able to change.
Darn it, I got a terrible screenshot.
And I said, I clearly can't figure this out, meaning the relationship.
You didn't say that. You said
I did.
Not
Hello.
the relationship. Your text messages, clearly I can't figure this out. I feel so lost right now.
What I was saying to him
No,
was
Ms.
clearly I
Hurd,
can't
Ms.
figure
Hurd,
this
Ms.
out.
Hurd,
as in
that's
the
not my
relationship.
question. The text, just the text.
That's exactly what I was saying.
What you texted.
Not what you were saying.
Clearly,
What
I
did you
can't
say?
figure this out. I feel so lost right now.
That's what you said.
That's what I was saying.
Okay. Thank you.
This is so funny.
Ms. Hurd, you contend.
Your Honor, just for clarification, so those two next lines did come in.
They are in the redacted
Okay,
copy.
good.
Yeah, they
All
were
right,
just
thank you.
published to the jury, Elaine.
And this incident took place on March 23rd, 2015.
That's correct.
And this supposedly occurred in the penthouse at the Eastern Columbia building.
That's correct.
We've moved on.
You had found text messages between Mr. Depp and another woman, right?
That is correct.
Oh.
So you confronted him about cheating on you.
That's correct.
You were the one cheating,
And
weren't
this
you?
was about 2 weeks after you had
Misheard.
returned from Australia.
That's correct.
So this is shortly after Mr. Depp supposedly sexually assaulted you with a bottle, right?
It was 2 weeks after he assaulted me. Yes.
And you decided to confront him about cheating on you?
I didn't decide to. I wanted to.
Mr. Depp's finger was freshly injured at this point, right?
He had a cast on it.
The
The
twisting of
top
the
of
words.
his right finger had been cut off 2 weeks prior.
That is correct.
And he had a pin in his finger, true?
I don't recall when the pin was placed.
That's fair.
The skin graft?
I'm not quite sure. He had several different procedures and they were kind of spread out over a period of time. So I don't remember what happened and when
One of those-
exactly.
Procedures was to treat the MRSA that got on his finger too, right?
At some point,
Yeah.
I knew he had an infection.
And his
That's
right
fair.
hand was in a bandage, right?
It was casted.
So it's your testimony that Mr. Depp was able to attack both you and your sister with his hand in that state, right?
That is correct. He had a hard plaster cast on it.
Debbie Lloyd was present in the penthouses when Mr. Depp supposedly attacked you. Isn't that correct?
That's correct.
In fact, you claim that Mr. Depp threw a Red Bull can at Miss Lloyd that evening.
Yes, that's correct.
And you put in a sworn statement to that effect in the UK case, right?
That is correct.
But that's not true, is it?
That's what happened.
You know what a deposition is, right, Ms. Heard?
I've had several, yes.
Yeah. So you know what it's when someone provides testimony under oath.
That is correct.
You're aware that Miss Lloyd was deposed in connection with this case, correct?
That's true.
And Miss Lloyd's deposition testimony was played earlier in this trial, right?
I'm going to object, Your Honor. May we approach?
All right.
Thank you, Elaine. Elaine turned on her microphone. Snaps for Elaine. Elaine also asked to approach instead of just arguing it out in front of the jury, which I appreciate. And Miss Lloyd's deposition testimony was played earlier in this trial, right? Ms. Bredehoff, I'm going to object, Your Honor. May we approach? Also, you don't have to say I'm going to object. You can just say objection and then state the legal grounds for the objection. Like that. The preferred method would be objection, hearsay. Objection lacks foundation. Ms. Bredehoff, you cannot impeach somebody else's testimony. We have to impeach with them that witness's testimony. She's testifying to what Ms. Lloyd testified to, attempting to impeach her, and that's improper. Ms. Vasquez, I'm not impeaching her with this testimony. I'm stating what statements have been made in court. The court during this trial. Ms. Vasquez, during this trial. Ms. Bredehoff, and that's hearsay. Shut the fuck up. Shut the fuck up. Oh my God. Where's my goat? Oh my God. I have 700 cups. That one's coming to the merch shop. Where is my goat? Damn it. I need to text Judge Abby. I need to be like, Your Honor, how do you explain to a lawyer that an in-court sworn statement is not hearsay? Oh my God. Oh my God. Law students. Hey, law students, ask your professors this. See if their heads explode. The court. Camille says, I'm stating what statements have been made in court. And the court says, during this trial. And Ms. Vasquez says, during this trial. And Ms. Bredehoff said, and that's hearsay for her to testify to what she says someone else testified. The court says, that's not. Elaine, oh gosh. If you are going to be a litigator, the hearsay rules are your art. They are your craft. The rules of evidence are the number one thing you need to know inside and out. with tabs and annotations. You wield them as your sword and your shield. This is how you do battle in a court of law, with the rules of evidence. And the lack of understanding for some of the basic rules of evidence, the basic and fundamental, not basic and lacking complexity. They are complex. But once you start working with them in court as a litigator, you start to understand. But is Elaine fucking with us? Because Elaine's like, this is how you properly impeach someone. Uh-huh. And then she's like, but Your Honor, that's hearsay. Are you fucking with me? Because I'm wondering if this is the strategy of like, no, I'm just a simple country lawyer. Because it's extemporaneous at this point. But I wonder if this is a strategy at this point. But what, Your Honor? Just in case it works. I don't know. Is this strategic? Hold on. I need my rules of it. I need my comfort rules of evidence. Hold on. Where are they? All of them. Come here. Look. Here's the thing. I saw a meme the other day, and it said that lawyers are basically attack librarians. I can't even say it. I'm going to snort. Oh my God. It basically said, lawyers are attack librarians, which is true. Lawyers use books. They use case law. They use research. They use rules, and they use those rules to their advantage and their opponent's disadvantage. This is the federal rules of evidence that you might want to carry into court. Look, if you're in a particular state, you might just want to have the one for your state. This is it. This is all. You've got a nice, concise treaty of all of your rules. All of it. And you can just get to where you need to be. But also, this just goes into court with you all the fucking time. All the fucking time. This is your life. This is your life when you need to study. The annotated rules tell you everything you need to know. It's just in there. This has the case law, key case law for your rules of evidence. It's so easy. I mean, it's not easy if you haven't been through law school, but once you've been through law school, this is your world as a litigator. This is it. Hold on. We're just going to go to hearsay real quick. And then we're going to just read the definition all together, so I feel like we're all on the same page. And then that's it. Definitions that apply to this article, exclusions from hearsay. We don't need those. Hearsay. Hearsay means a statement that the declarant does not make while testifying at the current trial or hearing. Hearsay means a statement that the declarant does not make while testifying at the current trial or hearing, and a party offers an evidence to prove the truth of a matter asserted in the statement. This is why I needed to give you all the background so you all could feel it with me. Statements that are not hearsay. And then there is a page of statements that are not hearsay and why they're not hearsay. Those are the hearsay exceptions. The rule against hearsay, Rule 802. Hearsay is not admissible unless any of the following provides otherwise: a federal statute, these rules, or other rules prescribed by the Supreme Court. If it meets the definition, it doesn't come in unless there is a rule that says it can come in. And then there's rules of the exceptions to hearsay under 803. Past sense impression, excited utterance. Law school was fun with declaring what was not an excited utterance. Then existing mental, emotional, or physical condition. Ow, ow, I've hurt my elbow. Is a then existing mental, emotional, or physical condition. There are other things that can count. Statement made for medical diagnosis or treatment. Why are you here today? I've been shot. Recorded recollection. Records of a regularly conducted activity. Those are going to get into your business records. Absence of a record that regularly conducted activity. Public records of vital statistic. Absence of a public record. Records of religious organizations concerning personal or family history. Certificates of marriage, baptism, or similar ceremonies. Family records. How do you know your name? It's hearsay. Someone had to tell you. No. Records of documents that affect the interest in property. Deeds, trusts. Statements and documents that affect the interest in property. Statements and ancient documents. Market reports or similar commercial publications. On and on and on. Sorry. Okay. Let's keep going. Let's continue on. We've gotten the point. I've belabored it too much. Apologies. Ms. Bredehoff, and that's hearsay for her to testify to what she says somebody else testified. The court, that's not. I'll overrule it.
You're aware that Ms. Lloyd was deposed in connection with this case.
That's correct.
And Ms. Lloyd's deposition testimony was played earlier in this trial.
Yes.
Yep.
So you heard Ms. Lloyd testify under oath that Mr. Depp never threw a can of Red Bull at her.
I can't remember if she didn't if she didn't recall that or if she said it didn't happen. I don't remember.
Let's go to the transcript.
I vaguely sense she didn't recall anything.
So it's your testimony that Ms. Lloyd would forget that Mr. Depp, a very famous patient of hers, threw a can of Red Bull that nearly missed her, according to your version of events?
To be fair, I just don't remember if she said when she testified that she didn't recall that incident or if it didn't happen. I don't remember what she testified to.
Mincing
but I have
words.
a vague sense that she didn't recall much at all.
Mincing words.
She recalled and she testified in this courtroom that Mr. Depp never threw a can of Red Bull at her. That was her testimony, wasn't it?
I don't recall what her testimony was with regards to that one incident, no.
You actually filed a complaint against Ms. Lloyd's nursing license right before she was supposedly deposed in this case, didn't you?
What?
No, I don't believe I did.
Are you aware that someone filed a complaint against Ms. Lloyd's nursing license in connection with her care of Mr. Depp for failing to report abuse?
No, I had no idea. You're the first person to let me know about that.
It's your testimony under oath. That wasn't you.
That is my testimony. I didn't even know about that until now.
So it's your testimony under oath. You threw nothing at Mr. Depp. Mr. McGivern's lying.
I have thrown things at Johnny.
No.
To be clear, but not that occasion.
No.
That evening.
Not that occasion. Not on that occasion.
So it's your testimony, Mr. McGivern. Imagine that you were throwing things at Mr. Depp from the mezzanine level down towards where Mr. Depp and Mr. McGivern were standing.
Well, he certainly wasn't going to say it about his client.
So he's lying. So you're calling him a liar. Everyone's a liar but you. That's her case. Everyone's a liar but me. That is her case. That is the best
But sir,
answer
you
for
and
Depp's
Mr. Depp
case.
kept a journal together, didn't you?
Yes, we did.
You wrote each other messages in that journal, right?
That is true.
Amber evades the question.
I'm
Camille
going to
just
move
keeps
for the
going.
admission of Plaintiff's Exhibit 91A, and I've gone ahead and redacted Mr. Depp's writings as on hearsay grounds.
I'm going to object your maybe.
Okay.
If you want the complete thing in, put the complete thing in. That's fine, but it's hearsay. Ms. Vasquez, I'm going to move for the admission of Plaintiff's Exhibit 91A, and I've gone ahead and redacted Mr. Depp's writings as on hearsay grounds. So at this point, Camille is trying to remember, if you lose the sidebar, the time goes against you. Ms. Bredoff, I'm going to object, Your Honor. May we approach? Okay. I can imagine the court's like, okay. Ms. Bredoff, Your Honor, I'm going to object on the basis of Rule 2106. When part of a writing or record, you could just say completeness when she must have something in front of her that she's reading. When part of a writing or record or recorded statement is introduced by a party upon motion by the other party, the court may require the offering party to introduce the other part of the writing or recorded statement, which ought, in fairness, to be considered contemporaneously with it, unless such additional portions are inadmissible under the rules of evidence. The court is like, which would be inadmissible hearsay? Which would be inadmissible hearsay? Unless portions are inadmissible under the rules of evidence. And the court's like, right, hearsay is the rules of evidence. Ms. Bredehoff, well, I don't know. I mean, I didn't have an opportunity to see which ones she's going to move. The court, she's putting in Ms. Heard's statements, not Mr. Depp's statements. The court, keep up. Ms. Bredehoff, but is she doing all of Ms. Heard's statements or just one? Oh, I think this is a strategic slowdown. Ms. Bredehoff, but is she doing all of Ms. Heard's statements or just one? Ms. Vasquez, some of them. The court, some of them. Ms. Bredehoff, then I would like to see if, in fairness, others of Ms. Heard's should be in there as well. The court, I'll overrule the objection. There wasn't even a legal grounds for the objection. It was just, Your Honor, can we have a chat? Ms. Bredehoff, may we be told which pages? The court, can you tell her which pages? Ms. Vasquez, yes. Ms. Bredehoff, will we know that before? Ms. Vasquez, I'm going to go through it as we go through it. The court, could you just tell her? Ms. Vasquez shouldn't have to. Ms. Vasquez, I'll call them out. Could you just let her know before you go through it which pages they are? Ms. Vasquez, sure. Ms. Vasquez, let's start with the first page. It's the picture. Ms. Bredehoff, Your Honor, they haven't given me the pages yet.
Let's start with the first page. It's a picture.
Your Honor,
It's a picture.
they haven't given me the pages.
Oh my God. Ms. Bredehoff, Your Honor, they haven't given me the pages yet. The court, can you tell them which page numbers they are? Ms. Vasquez, I'm writing them down. The court, okay, let's write them down first. Sorry, Judy, let's write them down first. Ms. Bredehoff, thank you.
But of course, I still, perhaps more than ever, want to rip you apart, devour you, and savor the taste. Fret not. XX Slim.
Yes, it's a love note.
It's your testimony under oath that you didn't report to Dr. Hughes, your retained psychologist, that you had cut yourself as a teenager once?
I said I had told my mom that I wanted to.
Oh, Dr.
When I
Hughes
was a
is wrong.
teenager.
Cool, everyone's wrong. Dr. Hughes testified to it.
You testified that during
Parsing
the
words.
incident on December 15, 2015, Mr. Depp broke the bed, correct?
That is correct.
And more specifically, you described that he broke the bed frame with his boot while trying to get purchase. Is
Have
that
you seen the
correct?
video by Lon
Yes,
Lumber
that's correct.
disproving that you can't break a bed that
Let's
way?
take a look at Defendant's Exhibit 509, which is already in evidence.
A video from Lon Lumber.
Mr. This is a picture that you
Is there a
indicated
knife in the
depicts the
bed?
broken bed, right?
The knife in the bed.
That's
the knife
exactly
in the
it.
bed. The knife in the bed. The knife in the bed. The knife in
It's
the
your
bed.
testimony that Mr. Depp caused this damage to the bed with his boot, right?
He did.
The knife in the bed. The knife
Is that
in
a
the
pocket
bed.
knife on the bed there?
I cannot tell what's on the bed.
Did you use that to damage the bed?
I did not damage the bed. Johnny's boot did when he was
It's
punching me.
happening. It's happening.
I could feel him slipping.
Let's go.
Mr. You also testified that there was blood all over the pillows on the bed, correct?
On the pillow top, yes. That's correct.
Get it.
But you didn't take a picture of that, though, did you?
I did not take a picture of this.
Ms. Vasquez, can we please pull up Plaintiff's Exhibit 1262? This is an email you sent on February 1st, 2015, correct? That is correct. Yes, that's correct. Okay. I'm
This
probably,
is an email you sent on February 1st,
mirrored from Johnny
2015,
Depp.
correct?
it's just my speculation.
That is correct. Yes, that's correct.
Oh, they're bringing in the wedding
I'm going to
invitation.
move to admit and publish Plaintiff's Exhibit 1.
I didn't do drugs, except it's on my wedding invitation. Oh, I'd been wanting to see this.
Sure.
I was so hopeful. It's happening. Oh, why are they approaching? Don't approach. I want to see it. We all want to see the dinner dancing drugs. I'm dying. I want to see it on the wedding invitation. We've heard so much about it. I'm going to move to admit and publish Plaintiff's Exhibit 1262. The court, any objection, Ms. Bredehoff? Yes, Your Honor. May we approach the court? Sure. The court, we'll get you down with that microphone eventually. It sounds like Elaine's microphone was not on when the court was like, any objection, and then was staring at Elaine, and Elaine was probably doing something with her face. And then the court said, we'll get you down with that microphone eventually. Ms. Bredehoff, it turns off and it's on its own, Your Honor. I put it on and then I don't realize it's off. The court, I don't think so. The court, Elaine, your mic. No. Ms. Bredehoff, I have to object more often so it stays on. Jesus, that's not the response. The court, all right, what's your objection? Ms. Bredehoff's trying to be cheeky with the court at this point. It's too far gone. The court's not amused. Ms. Bredehoff, this was produced after. This is not in the exhibits that defendants have. Ms. Vasquez, I don't think that's true. Ms. Bredehoff, 1262, which was not in their trial exhibits. The court, is it in your evidence? Ms. Vasquez, well, nevertheless, this is an email from Ms. Heard. I'm not certain that that's true. First and foremost. Second of all, this is an email from Ms. Heard. The court, okay. Ms. Vasquez, and I can use her statements after the fact. The court, all right. Ms. Bredehoff, but it's not for impeachment purposes. The court, is it a plaintiff's? Ms. Vasquez, plaintiff's, yes. Ms. Bredehoff, it should have been provided in discovery, Your Honor. We produced our exhibits. Ms. Vasquez, it's not direct examination. Ms. Bredehoff, but it's not impeachment. And there's nothing about it that's impeachment. Interesting. Ms. Vasquez says, it is. It's her statement. It's an email. She just testified. I laid the foundation, and frankly, Ms. Heard should have produced this. This is her email, Ms. Bredehoff. She should have produced it. Ms. Bredehoff, this was produced in discovery. This was in discovery. She was asked about it in the UK, Your Honor. Ms. Vasquez, so it was produced in discovery. So what's the objection? Like the circular argument here that Elaine caught herself in. It's your client's email. It was used in the UK. So what's the problem? So it was produced in discovery. So what's the objection? Elaine is snappy. The court, what's your objection, Ms. Bredehoff? Because it's not a trial exhibit. But it's cross-examination. Because it was not a trial exhibit. That's what we got objected to. The court, I think it's exhibit A is in exhibit. Ms. Bredehoff, it's not one of our exhibits. Ms. Vasquez, it has a Bates number. It was produced in discovery and it's my exhibit. Ms. Bredehoff, it's not a trial exhibit. The court, it's cross-examination. Ms. Bredehoff, but it's not impeachment. There's nothing that impeaches her. The court's like, we're not going round and round. I'll overrule the objection. Elaine is trying to say you can't get it in. Camille is saying it's cross-examination. I can cross-examine her on her own statements. This is a statement. It's not hearsay because it's a party opponent. And it's just like, okay, what's in the fucking email? This is a schedule. Oh, I loved this part. This was funny. I was not expecting this at trial. This is a schedule for your wedding weekend, right, Ms. Heard? No, it's not. It's a proposed draft of a schedule. It ended up being quite different.
This is a schedule for your wedding weekend, right, Ms. Heard?
Yes!
No, it's not. It's a proposed draft of a schedule. It ended up being quite different.
So your
As I
original
called
idea
it,
was
huddle
to do
puddle
drugs.
before.
Yeah, your original idea was to do drugs on an island after your rehearsal dinner to the drug-fueled monster that you were about to marry, right?
Thank you, Mom Sillin.
As the email suggests, there was going to be weed on the island. This does not reference the cuddle puddle that I just referenced to you.
Let's look at Plaintiff's Exhibit 1263.
Your Honor, I'm going to ask to show, first of all, this one hasn't been produced. This has not, it's a brand new trial exhibit, so I don't have it. I'd like an unredacted
impeachment.
copy, and then I'd like an unredacted copy to be shown to the witness.
Once
Do you
they
have an
just
unredacted copy?
once they decide to use it, they should be turning over the
We can make
unredacted.
one, Your Honor.
But
Okay.
I said I would
Your
not
Honor,
bite
we
his
can
head off.
approach about
All
this.
Get it, Camille. Court, do you have an unredacted copy? Ms. Vasquez, we can make one, Your Honor. The court, okay. Ms. Vasquez, Your Honor, may we approach about this? The court, all right. Ms. Bredehoff. Ms. Bredehoff, oh, I'm sorry. Was Elaine not paying attention that they all went up to Sidebar without her? Ms. Vasquez, Your Honor has already overruled Ms. Bredehoff's objection that it's not on our exhibit list because that's not a legal objection. The court, I know for cross-examination, you did it too. We entered new evidence for your cross-examination. Ms. Bredehoff, Your Honor, didn't allow any of our new evidence in. The court said, no, that's not true. Ms. Vasquez, cross-examination. The court, here's all the 1804, 1558. Ms. Bredehoff, those were pictures from Ben King, Your Honor. That's the only one we were able to allow in. And that's because they didn't produce them in discovery. Ms. Vasquez, cross-examination doesn't have to be on the exhibit list. It says exhibit, but whatever. Ms. Bredehoff, they have to give us an unredacted copy so we can see it. The court, I understand now, but it doesn't have to be on their exhibit list to have cross-examination. You agree with that, right? The court is trying to go back to like the basic trial functions. Elaine, you understand that cross-examination is different than direct examination. And things can come up in cross-examination that don't have to be disclosed. And so the court's like, you agree with that, right? Like the court is trying to check in with Elaine that Elaine also agrees with these basic principles of like trial. And Ms. Bredehoff said, well, it depends. Erroneous. I mean, unless it's barred by other rules of evidence, I guess then it would depend. Ms. Bredehoff, well, it depends. I think it depends on the circumstance, Your Honor. Cross-examination just doesn't, if it's for impeachment purposes and rebuttal purposes, yes. Well, no, actually. It has to not be otherwise objectionable. It can't lack foundation. It can't be hearsay, but it can come in on cross-examination even if it's not disclosed to you in the trial exhibitees list. The scheduling order was quite clear. If it's not on your exhibit list and it's not for impeachment, it's not permitted in. It depends upon whether it's for impeachment or rebuttal. The court, well, we're past that. Ms. Bredehoff, I don't know what this document is. The court, if you need to see it, but they need to see it they need to see the unredacted part, which is fair. If you are going to use an exhibit on cross-examination, the other side should be provided with it so they can see what the full exhibit is, even if that's not what's going to the jury. Ms. Vasquez, the only thing redacted, Your Honor, is I'm going to show her one text message. The only thing redacted is personal identifiers. The court, there's a whole chunk there. I just don't know what's there. Ms. Vasquez says there's text messages from other people. I was trying to make things a little easier. This is how Ms. Bredehoff produced her text messages. So it has text messages from a bunch of people. The court, is there something that was supplied? Is there something that was supplied to you from them? Ms. Vasquez, yes. The court, do you have it in discovery? Ms. Vasquez, it's there. I mean, this is how Ms. Heard produced her text messages. Okay, so keep reading, Emily. Camille is saying, Your Honor, I don't know if we have an unredacted because this is produced by them in discovery. So Elaine is objecting to an exhibit that they are using in cross-examination that she produced in discovery to Team Depp. Oh my God. Okay. It's there. I mean, this is how Ms. Heard produced her text messages. Ms. Bredehoff said, we gave copies to them of everything we had, Your Honor. They're now not giving us copies, but then they're giving us copies of redactions. We need to be able to look at it. The court said, I agree. Ms. Vasquez says it's just a text message. The only thing redacted is it's one text message that I would like to present. It's hers. The court said, I understand, but they're entitled to see the unredacted page. Ms. Vasquez says, okay. The court says, so if you don't have that now, maybe you can try later. Ms. Vasquez said, I have it. We can show it to her. But it seems like they're arguing over stuff Elaine produced. These are text messages that Heard produced to them. The court said, okay, just show her that. Ms. Vasquez, thank you. Okay. Ms. Bredehoff, thank you, Your Honor. This is why shit needs to be bait stamped if it's turned over, so that Camille could just say it's bait stamp number whatever. And then Elaine can flip through her book and just be like, oh, there's the unredacted version.
I'm going to show the unredacted messages.
The jury will get all the evidence
Heard on a laptop because I don't have a hard copy.
Okay.
Ms. Vasquez, I'm going to show the unredacted message to counsel for Ms. Heard on the laptop because I don't have a hard copy. The court, okay. Ms. Bredehoff, let's just approach for a minute. Is this the next sidebar? The court, what's that? Ms. Bredehoff, during the lunch break, Your Honor, they give us hard copies. So at least I'm not asking them to give it to me in advance. But if they don't have hard copies, at least during the lunch break, the court, they'll get you hard copies for the ones at lunchtime moving forward. Ms. Bredehoff, moving forward. The court, moving forward. Ms. Bredehoff, that's fine. And then hard copies of whatever they can't give me now. The court, right. You'll just look at the laptop. Ms. Bredehoff, I understand that. Ms. Vasquez will produce it. Ms. Bredehoff, but at the lunch break, if they can give it to me, the hard copies, the court, that's fine at lunchtime. Okay. Ms. Bredehoff, thank you. Open court. So now they're looking at the unredacted evidence.
I'm
The
only
mirror
going
side by
to-
side.
I'm going to object to asking questions while I'm looking at this.
They can't for
If you could give her a
closing.
moment, please.
Sure.
Thank you.
She was talking to the court, Elaine. So Ms. Heard. Ms. Bredehoff. Your Honor, I'm going to object to asking questions while I'm looking at this. The court, if you could give her a moment, please, Ms. Vasquez. Sure. Fine. The court, thank you. Okay, Ms. Vasquez, thank you, Your Honor. The court, all right. Thank you, Ms. Vasquez. Okay, the court, any objection? No, Your Honor. All right, thank you.
Ms. Heard, directing
Is she
your
the oldest
attention
Leonard at
to
78?
the Plaintiff
Maybe not.
Exhibit 1263. This is a
Welcome.
text message that you sent to Mr. Depp, correct?
That is
Ooh,
correct.
Text
And,
messages.
you sent this message to Mr. Depp the day you had your 30th birthday dinner, right?
That is correct.
And you write, quote, "Hey baby, bring up something to drink and or a joint. I'm in if you are. See you in a minute."
Let's do
At
drugs.
sex. Did I read that right?
That is correct.
You and your friends went to Coachella to celebrate your birthday. Is that correct?
That is correct.
You made a video driving to Coachella with your friends, didn't you?
That is correct.
There's a video?
I'd like to pull up Plaintiff's Exhibit 1264.
There's a
For the record,
video?
Your Honor, this only has
There's a
music
video.
without any words on it.
And again, it's a new one, so I'd
Is
like
it
a
from
copy of it.
Instagram?
It's
Let me
going
see
to be played.
It's going to be played. I would like a copy of it. It's going to be played. It must be an
There
Instagram
is no sound other than a
May we
song.
approach?
Yes, sure.
video. May we approach? Did you hear the judge? Yeah, sure. So we have an audio tape. That's a brand new exhibit. Ms. Vasquez, video. Ms. Bredehoff, video? And I'd like to see it before she shows it to the jury. Oh, this is from social media. Ms. Vasquez, can we play it for the witness and counsel without sound? And then you can publish it to the jury. The only sound is the music, so it doesn't have any lyrics. The court, all right, you want to view it just for the witness and counsel? Sure, thank you. Any objection? No. And then the video is played. Saw that the
No,
jury
you're-
responded
okay.
positively to
Could you
Dr.
please
Curry
Publish this to the jury.
Evidence.
and is trying to
with,
mimic
sound.
or emulate that. And I think that goes along with Dr. Curry's testimony. Publish it. Publish it to the jury. Darn it, don't we get any more?
This is a video you made when you drove to Coachella with your friends for your 30th birthday, right?
That's correct. I'm not quite sure which one of us made the video, but that's correct.
That's fair.
You're featured in that video driving.
That's correct.
She
And it's
wasn't
set to the
filming it.
song "Miss You" by the Rolling Stones. Is that right?
That's correct.
That was a message for Mr. Depp, wasn't it?
Ooh.
No, that's ridiculous.
You were sitting here in this
Everyone's
courtroom
lying.
when Officer Melissa Sines testified by deposition about being called to the Eastern Columbia building on May 21st, 2016, right?
I saw her testimony, yes.
And you heard Officer Sines testify that she did not see any injuries on you that night, correct?
I heard her testify she did not consider this injured.
No.
She sure
Miss
remembers
Officer
all this
Sines
testimony.
Testified that she met with you and she did not see any injuries on your face. Isn't that correct?
She did not consider this injury.
That's not what she said.
Ms. Heard, my question is a bit more nuanced.
Mm-hmm.
So is my answer.
Oh, snap. Why don't you pull up the testimony and just impeach her with it? Ms. Bredehoff, Your Honor. Ms. Heard, so is my answer. Ms. Bredehoff, may I approach the court? All right. The court, what's the objection? Ms. Bredehoff, again, she's reciting other people's testimony, which Ms. Bredehoff, her version of these can do. The court is saying, which she can do. What Ms. Bredehoff is not saying is objection misstates testimony. Because I don't think at this point Elaine understands misstates testimony as the proper formulation for that objection. But also, I think she's trying to slow down the testimony or the cross-examination that hurts Amber Heard, but it makes it look like she's trying to bail out Amber Heard. What's the objection? Again, she's reciting other people's testimony, her version of these, the court, which she can do. Ms. Bredehoff, Ms. Heard is responding exactly correct. I wonder if Amber could hear her saying that. Ms. Heard is responding exactly correct. Officer Saines said she didn't consider that an injury, the court, that was when she was seeing the picture. But her original testimony is the deposition we played was that she said she didn't see any injuries. You showed her a picture. She said she didn't consider that an injury. Ms. Vasquez, two different things. Ms. Bredehoff, that's just improper cross-examination. No, that's good cross-examination. That's exactly proper cross-examination. Elaine is trying to conflate the two testimonies and say that the testimony that she finds more specific and helpful to them is the only testimony. And the court, after paying attention to this trial and hearing all the testimony, said, no, those are two different things. Ms. Bredehoff, it's just improper cross-examination. The court, it's not improper. It's not an out-of-court statement. It's an in-court statement. Ooh, that could be said a lot of ways from the court. The court, it is not improper. It's not an out-of-court statement. It's an in-court statement. Though I could hear the court screaming this because in my brain, I am screaming. Ms. Bredehoff, it's Ms. Vasquez testifying to what that woman testified to. It's hearsay. Hold on. Let me get back to Rule 802 real quick. Let's get back to the definition of hearsay. The court should have just started reading the book. The court was too fucking tired and put out to start reading the rules. But hearsay means a statement that the declarant does not make while testifying at the current trial or hearing. So calling testimony hearsay is the stupidest shit I have ever seen. How do you even explain it? The court, it's not hearsay. I've sustained this over and over. And for the record, you can have an ongoing objection. Elaine objects. Objection, Your Honor. Effective cross-examination. Ms. Bredehoff, thank you. This is so dumb. The court overruled. Ms. Bredehoff, this time, in addition to that objection, Ms. Heard is correctly characterizing what Officer Sands testified to. Ms. Vasquez, no, she's not. The court, no. I just told you that was two different statements made by the officer. And on redirect, you get to come up and say exactly what happened. Ms. Bredehoff, okay? But please, also, don't be so animated when you lose an objection. Last time you left here, Ms. Bredehoff, I apologize. I caught myself right after it. The court said, I almost brought you right back. Ms. Bredehoff, I apologize. I did not mean to do that. And you're right. I should not have done that. The court, I will call you back next time. Don't do it again. Ms. Bredehoff, I won't. Ms. Vasquez, thank you, Your Honor. Yeah, Ms. Bredehoff had like a temper tantrum when she lost her objection and was just like, she kept doing that. Ms. Vasquez, Tom, can we put these down, please? I think they might be confusing the witness. I think they're confusing Ms. Bredehoff.
In fact, there was a lot of reasons why you were no longer active in these endeavors. Isn't that right?
Oh, dear. Where are we going?
I disagree with that.
Reasons that had absolutely nothing to do with Mr. Waldman's statements. Isn't that right?
I disagree with that.
What that is.
There was a lot of publicity about your relationship with Mr. Depp around the time Mr. Waldman made the 3 statements at issue, right?
I do not recall.
A lot of really negative publicity for you, Ms. Heard. Isn't that right?
There's been an ongoing smear campaign, yes.
An ongoing negative publicity campaign.
It's an orchestrated smear campaign.
Orchestrated smear
You have no
campaign.
evidence of that, do you, Ms. Heard?
Just look me up, you'll see.
The jury can't look you up, Ms. Heard.
All right.
Let's take a look at some of that. Ms. Vasquez, Your Honor, may I approach the court? All right. Sidebar. The court. Okay. The articles. Ms. Vasquez, the articles. The court. Okay. Ms. Vasquez, so obviously there's a copy for you, Your Honor. The court, sure. So I plan to do the same thing with these, Your Honor. Ms. Bredehoff, these are all new exhibits at this point, Ms. Heard. Wait, these are all new exhibits that point to Ms. Heard. There can't possibly be a reason why they wouldn't have to put them in the trial exhibits before. They knew she was going to be making these claims. Well, then so did you, Ms. Vasquez. This is exactly what Mr. Rottenborn did during cross-examination of Mr. Depp, and they're not going to be admitted into evidence. I just plan to read the headlines. The court, read the titles, the headlines, like he did. Ms. Vasquez, there you go. Ms. Bredehoff, first of all, Your Honor.
Let me just put on the record, it is not correct. That's exactly what Mr. Rottenborn did. Those were in our trial exhibits. In fact, they're in the very first part of our trial exhibits were all of those. So I don't have an ongoing objection to using anything that wasn't put into evidence as part of the trial exhibits. They knew she had a counterclaim. They should have had it as a defense, part of the exhibits.
The court, I understand your observation. Again, it's cross-examination. I'll allow them. I want to give you an opportunity. You're not going into the text of the articles, just talking about the titles and date. Ms. Vasquez said, I plan to read the title, and then I'm not going to be admitting them into evidence. The court said, not into evidence. Ms. Bredehoff, we'll need copies. The court, you'll get those copies. Ms. Vasquez, I'll get them copies. The court, are you saying all of these are for the three statements? Ms. Vasquez, yes. The court, okay. Ms. Vasquez, there you go. Your Honor, I have a question. Yes, Elaine, of course you do. It feels like everybody's on the same page, and then Elaine's like, what? What happened? The court, sure. Ms. Bredehoff, if we can look at 1272 for a moment, that's May 29th, 2020, which is after two of the court. I'm sorry, I'm having trouble hearing you. Ms. Bredehoff, oh, I'm sorry. The court, that won't help me. I appreciate it. That's not me. That's Judy. Which one? Ms. Bredehoff, if you look at 1272, the date's May 29th, 2020. I'm obviously seeing these for the first time, Your Honor, so I'm trying to go through them. The court, remind me again. Ms. Bredehoff, two of the April 8th, April 28th, and the court June 24th, laminated. It helps me. So that May 2020 would be after two statements. Ms. Vasquez, that's right, Your Honor. And I think for relevance, Ms. Bredehoff's objection is that they're not being cited in the title to Mr. Waldman's statement. It's talking about another allegation that was out in the press. So for Ms. Heard to allege that Mr. Waldman's statements caused her to lose opportunities, and there's articles before and after that were in the press. And I think we have to argue that, Your Honor. Ms. Bredehoff, so Your Honor, I'm trying to keep up, Your Honor. The court, that's all right. Take your time. Because she's now trying to flip through the articles. Ms. Bredehoff, this last one is 1273, Your Honor. I don't see a date on it. The court, 1273, I don't see a date either. Ms. Vasquez, May 24th, 2020. The court, yes. So we'll take out 1273. I'll sustain the objection to 1273. Ms. Bredehoff, Your Honor, I would object to 1274 too, and that title. I think it's not a reputational issue for her if somebody makes an allegation about her having an affair. I don't think it's appropriate. I don't think it's, the court said, yeah, okay, all right. Ms. Vasquez says, I mean, we just admitted evidence today about her having an affair with James Franco the night after April 21st. So these are all allegations. Ms. Bredehoff, it's not an allegation. The court, I'll take the objection on this one. All right. I don't know what the court means by that. I'd be like, what do you mean I'll take the objection? Is that sustained? Is there any more than that? Ms. Bredehoff, this is after three articles. The court, this is after all three articles. Ms. Vasquez, Your Honor, again, it's surrounding about the statements that they were. The court, so you're saying you're not offering just for her reputation before, you're offering for her reputation after as well. That affects her reputation. Ms. Bredehoff, I think that opens up the door, Your Honor, to the UK judgment. I think she gets, if she opens up the door. The court, she's doing damages. She has a limit to her damages. She's starting her damages after 2020, correct? Ms. Bredehoff, Your Honor, this one is testimony from the trial that says Amber Heard stole my sexual assault story. Ex-aide tells libel trial. The court, right. We had a lot of testimony from the UK. I feel like I've been at the UK trial. I don't see how that would open any door. That's funny. The court's like, right. I feel like I've lived there. The court's like, I traveled to the UK and I didn't even know it. Didn't get a stamp on my passport or anything. Ms. Vasquez says it's public knowledge, Your Honor. Ms. Bredehoff, I don't think that it's an appropriate one. Again, she's testifying. Ms. Vasquez, she testified here, the court, just the headlines to talk about reputation. That's out in public about her reputation. I mean, I did about 25 on Mr. Depp and all kinds of different issues of reputation. I think that goes to damages. Any other ones? Ms. Vasquez, sorry, Your Honor. Ms. Bredehoff, note my objection, but I understand your ruling. The court, I'll note your objection. I'll overrule your objection. Thank you. I appreciate it. Any more? Ms. Vasquez, yes, I'm sorry. The court said, okay, last one. So they are going through whether or not these articles headlines will be read out to the jury. They're still going through those at sidebar. Hold on. Are you going to go the rest of today, Ms. Vasquez? No, I'm not going to take the rest of today. The court, I assume you'll have these questions and then we'll break. Is that okay? That's fine. You're going to go into the afternoon and then maybe after the first break, we'll be on redirect. Sounds good, Ms. Vasquez. Thank you. The court, back to court.
So
this is a
Ms.
great
Hurd,
question.
My last question to you was that there was a lot of negative publicity for you around the time that Mr. Waldman made these statements. Isn't that correct?
I believe that they were made. I believe that the statements kind of kept being attached to new defamatory or, articles that were like smear campaign sort of attack articles is what it.
Okay.
We're now on page 60. Recess taken for lunch. This is back from lunch. All right, Ms. Vasquez. So I plan to ask Ms. Hurd about the arbitration. So Ms. Hurd, the court said arbitration. Ms. Vasquez was served with an arbitration demand and the court said arbitration for what? Ms. Vasquez, defamation. The court said the arbitration for this case. Ms. Vasquez said, yeah. Ms. Bredehoff said, no, it was a breach of contract. Ms. Vasquez, no, it was defamation. The court, it was defamation. Ms. Vasquez, a demand for arbitration for defamation in California in October 2018. We've argued that. The court says, okay. Ms. Vasquez says, I'll give that to you. The court says, okay. Ms. Vasquez, we've argued that Ms. Hurd opened the door when she talked yesterday in response to Ms. Bredehoff's questions about how statements, Mr. Waldman's statements have been traumatizing to her. And she said, I just want him to leave me alone. I wanted to move on with my life and he won't let me. By making cases like this, he won't let me. I have to be here today. I have to be reliving it every day. The court said, right. Ms. Vasquez said, so we are arguing that she opened the door, that she was the one who fired the initial shot when she attempted to move arbitration against Mr. Depp 2 months before the op-ed was even published. So it was October of 2018. The op-ed was published in December. The court said, okay, give me more background on this for arbitration. What was this arbitration about? Ms. Vasquez, oh, I didn't know this. It was interesting when it came up in the cross-examination because when Amber Heard kept saying, I just want to move on, but I've been dragged here. It's like, well, yeah, she's been sued. She has no choice but to be here. And then when it comes back around on cross-examination, it's like, you actually tried to force all of this to arbitration first. You indicated you were going to sue first. Well, who sues first gets the choice of venue. So I can understand Depp's team being like, well, if you're threatening to sue me, fuck it, we're suing you. That's shots fired. So I get it. I was really surprised when this came up in cross-examination during the trial because I had no idea. This was interesting to me. So I love seeing them argue about it behind this. So let's see. The court, okay, give me more background for this arbitration. What was this arbitration about? Ms. Vasquez, Ms. Hurd's arbitration actually filed by Ms. Hurd in California, the court before the op-ed, Vasquez before the op-ed. It also goes towards the statements that she can't, Mr. Depp suing her. So that distorts credibility. Oh, can't, this is indiscernible. I'm wondering if it's pay the, she said she couldn't fulfill the pledged donations because of the suit. The court, okay, and she filed for arbitration for it. Ms. Vasquez filed arbitration for defamation. The court said defamation from what? Ms. Vasquez said for Mr. Depp denying in an article, a GQ article, that he ever hit her. So she sent an arbitration demand over a GQ article over statements made by Mr. Depp, not statements made by Waldman. The court said, okay. Ms. Bredehoff said, this is a subject of a motion in limine. Your Honor granted a motion in limine and said none of the arbitration can come in. The arbitration was filed to go back to the divorce, and it was a breach of contract, a violation of the court said, right. So it was a divorce, all right? Ms. Bredehoff said the divorce decree. The court said, okay. Ms. Bredehoff said the arbiter ended up finding he did not have jurisdiction, and that was the end of it. There was no finding. There was no nothing. The court said, okay, but you just want to get into that she filed the arbitration. Ms. Vasquez says, right. The fact that she fired the first shot, not what happened at arbitration. Ms. Bredehoff says, I don't think she said anything about arbitration. Oh my God. Elaine, that's not what she said. Open the door. Ms. Bredehoff said, I don't think she said anything about the arbitration. I was just saying that he violated the terms of the domestic relations order. He didn't deny a public filing. It was very, very private. The court said, oh, okay, all right. I remember this now. Okay, sorry. Yeah. In dealing with the divorce, the arbitration, she's saying that he violated the terms of the agreement. Ms. Bredehoff said, by this Gentleman's Quarterly article. I love that she just lists out GQ by Gentleman's Quarterly instead of saying GQ. That is sending me. Okay, Elaine. Okay, Elaine. By this Gentleman's Quarterly article that he wrote, Ms. Vasquez, it wasn't violating the divorce agreement. It was an actual demand arbitration for defamation. The cause of action was defamation. I have the exhibits. So the fact that she filed it before the op-ed came out is highly relevant. And she opened the door with her testimony that Mr. Depp won't leave her alone, and she filed a counterclaim after the fact. So I think it's relevant, Your Honor. She opened the door. She said that these counterclaim statements continue to make things difficult for her, and she can't stop reliving it. But in fact, she's the one who fired the first shot. She just wanted to be left alone. Well, then why did she demand arbitration? I guess the flip side to that argument is she demanded arbitration so this wouldn't be a public lawsuit so she could be left alone. I mean, that would be the other side. I don't know. The court said, okay, but that's Bredehoff's argument to make. Ms. Bredehoff said, I don't know how that opens the door at all, Your Honor. This was an arbitration filing that the arbiter found there was no jurisdiction, so he dismissed it, and she didn't do anything further. The court said, I know, but she filed it. What she's saying is because she testified, I wanted to be left alone. I didn't want to have anything to do with it, but then she filed this. So I'll allow limited questioning. Ms. Vasquez, very limited, Your Honor. The court, what was the questions you were going to ask? Ms. Vasquez said, I wanted to repeat her testimony from yesterday, in which she says that she wants to be left alone. I'm going to ask her, you commenced a legal proceeding against Mr. Depp for defamation in October of 2018, and that was blank allegations. And then the court said, commenced an arbitration, right? Ms. Bredehoff, yeah, I think she can't say legal proceeding because that's arbitration is very different. I mean, the court said is different. I agree. Commenced an arbitration. I mean, an arbitration is a legal proceeding, but okay. Ms. Vasquez, I understand. I'm happy to do it that way. And then, so I want her to look at the demand for arbitration. I'm not planning on publishing it. The court said, I think you get the first question and that's all I'm going to do. Ms. Vasquez said, this is a demand for arbitration filed against Mr. Depp in California, correct? Ms. Bredehoff said, I don't know how that would be relevant. The court said, no, I think she opened the door with the first question about you did file it. Ms. Vasquez said, my question is that Amber Heard plaintiff versus Johnny C. Depp. I just want to show the caption. Ms. Bredehoff said, why would she need to do that? She can just, Ms. Bredehoff said, in the signature block signed by her attorney, she testified that. The court said, I'll give you the first question. And I think that's fair since and the date of when it happened. Ms. Vasquez said, okay. And can you confirm it was October 2018? The court said, okay. Ms. Vasquez, and that's 2 months before the op-ed. The court said, that's fine. Ms. Vasquez said, and 6 months before Mr. Depp filed his defamation case. The court said, that's fine. Very limited. Ms. Bredehoff, nothing beyond that. The court, okay. Ms. Vasquez, okay. Okay. All of it, okay. Okay.
Is that one of the statements
My
that
fault.
you allege are defamatory? It's defamatory?
That's correct.
The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911. But even this didn't have, apologize. You're fine.
Turn on your mic, Elaine. If you're going to object and ask to approach, at least turn on your mic so we can hear what's happening. Ms. Bredoff said, Your Honor, may we approach? Ms. Bredoff, she's reading beyond his statements. Ms. Vasquez said, I stopped myself. The court said she stopped herself. Ms. Bredoff said, okay. Because she placed a second call to 911 is where it stops. She kept reading, but even this didn't have, and then said, apologize, and stopped. Ms. Vasquez said, actually, Your Honor, while we're up here, I tried to work this out with Ms. Bredoff. Unsurprising to you. Oh my God. Unsurprising to you, we were unable to come to an agreement. I'm going to be moving to admit these articles in their entirety. Okay. And the reason is, Your Honor, it's that just like the op-ed, it came in the entirety through Ms. Heard, though Ms. Heard is only alleging 3 of the statements. The court said correct. The court said for defamation, you have to look at the context. Ms. Vasquez said correct. So to evaluate the defamatory meaning, so on that basis, I'm going to move to admit it. Ms. Bredoff said, I'm going to object, Your Honor. There's a lot of hearsay in both of these documents. It's different than the op-ed. The op-ed is Amber Heard writing the op-ed. She's right about that. The op-ed is Amber Heard writing the op-ed, and then to be questioned on it, there's also the issue of a matter of public concern and intent. The rest of this article is not Adam Waldman's and it's not Johnny Depp. It's other people saying things, and it's hearsay, and it's highly prejudicial to Ms. Heard. The court said, okay, I understand Elaine's argument there completely. Like, it's an op-ed's written by the party opponent here. We get that, but the GQ article, totally different. The court said, okay. And Ms. Vasquez said, well, I disagree. And Ms. Bredoff said, and it doesn't have anything to do with the context of what he said. The court said this might be a partial, Ms. Vasquez said a partial. The court, maybe it could be connected to, Ms. Vasquez said, I think if I may just be heard on this, the court said, all right. Ms. Vasquez said, this is really important to Mr. Depp. Obviously, the alleged defamatory meaning of Mr. Waldman's statements have to be read in context. And I should point out to you, Your Honor, that Ms. Heard, not Ms. Bredoff, but previously Ms. Heard, was represented by other attorneys in this matter, and they're commenting in this article. And so Mr. Waldman's statements are really responsive, we argue, right? I'm not sure Ms. Bredoff will agree or disagree. We argue that these statements are opinions first and foremost, and second of all, that they are response or self-defense of Mr. Depp in this case. Self-defense is not a defense. Self-defense is not a defense to defamation. Truth is, self-defense is not. So, I think that it's important that these articles come in their entirety. Of course, we know that didn't happen. Again, to be perfectly frank, these aren't great articles for Mr. Depp. I don't plan to publish them to the jury. I just want to submit them into evidence. If they're in evidence, the jury can see them. So Ms. Bredoff says, if I may be heard on that further, Mr. Waldman doesn't know what else is in the article when he made the statements. That's a fair argument. That's somebody else choosing where to put different things. You don't really know, because you could have reporters saying to him, well, this person said this. What do you think? This person said that. What do you think? You can have a reporter asking for a response. So I don't know. It's a fair argument. Though I can see the other side of it. That's a good argument to make in the moment for Elaine. He has admitted, and we will be putting the testimony in, that he made those statements, but he wasn't the author of this article. So the content is not relevant to what their meaning was on it. Instead, it would have a lot of hearsay from other people that he had no control over. He had control over what he said and he was not saying, and what he was not saying. And there's no way they could prove that he had knowledge of what the rest of the article is going to say, and therefore have context. That's a really good argument, Elaine. I think it's highly prejudicial and very much hearsay. The court said, all right. So how could the context of the article change the extent of 714? The exhibit. I think she's referring to the exhibit, not the rule of evidence. Ms. Vasquez said defamatory statements have to be read in the context of the other text within the article. The court said, if it's all attributed to Mr. Waldman, and that's fair on the court saying, but not all of this is attributed to Waldman. Ms. Vasquez said, no, I don't think that's true. I mean, and the court said, I think so, because somebody else can't place his statements there and it become defamatory because they're placed within the article. Ms. Vasquez says, I think they have to be read in context, Your Honor. And the court said, I'm going to sustain the objection.
Now, you've heard this audio before, haven't you, Ms. Heard?
Yeah, we've already had this trial before.
Yeah, you've played, it
We've
was
had this
played for
trial
you when
before.
you were deposed in
No, you haven't.
2016 in connection with your divorce from Mr. Depp, wasn't it?
You didn't have this
That's one
trial
of the
before.
times I've heard it, yes.
So you've had plenty of time to think about how to respond to this recording, haven't you?
I don't know what you mean by that.
Interesting.
Well, let's take a look at how you responded to it the first time.
Oh.
Can we please pull up what will be marked
You're changing your
Plaintiff's
testimony.
Exhibit 1261?
That's what she's getting at. You're changing your testimony. You've had plenty of time to think about how you're responding, and now
The
you've
next
changed.
thing that I'm going to play to
Your Honor?
you
Okay.
as cue.
There's an objection.
Oh, if you want to come?
She keeps saying new. This isn't new. If it's the deposition, it's not new. Your Honor, this is another new. The court, do you want to come to the bench? just stop. The court, is this her deposition? Ms. Vasquez, correct. In the divorce proceeding. The court, you've got to give us a reference point. Ms. Vasquez, I apologize. The court said, so we know. Ms. Vasquez said, Ms. Heard was being deposed and we played this recording. Ms. Bredehoff, that's improper. Where you impeach, you need to ask the question, and then if her answer is different from her deposition, then she can play the question and answer. Oh shit, we're doing it again. We're doing it again. The court said, this is cross-examination. Ms. Bredehoff said, well, I understand it's still cross-examination, but there's still a proper way to impeach and an improper, they're not impeaching her. They're crossing her. It's so, there's still an improper, and there's still a proper and improper way to impeach. You can't just play the deposition excerpt and say, so. Okay, Elaine. The court, she did ask the question. She said, let's see how you did the first time. So I assume it's a different answer to the question, but I don't have a copy of that. I would just like to know what we are referencing in the, or where we are referencing in the deposition. Ms. Vasquez, absolutely. Ms. Bredehoff, the deposition. If we could get the line and page number. The court, the line and page number before we start. Ms. Vasquez, I will do that. Let me do that. Which is fair. Ms. Bredehoff, and we can see that. And Ms. Vasquez said, thank you. Oh, the amount of shit that Camille is navigating in this cross-examination is wild. Because not only does she have to focus on and handle the witness, which is contentious, but then also has to navigate all of the wildness going on in the bench with Elaine. This is why this part of trial is so exhausting, because you've got so much going on in your brain. It's wild. Ms. Vasquez says, I'm going to read it into the record and then I'll hand it off to you. Ms. Bredehoff said, I would like a copy. Ms. Vasquez said, I will. So, Your Honor, for reference, and I will provide a copy of the deposition. Ms. Heard's deposition in the divorce, I mean, they already have it, is page 372. Like Elaine at Code doesn't have Amber's divorce deposition. Come on. It's so much. It's page 372, starting at line 5 through 377, line 12. The court, all right, I think. Ms. Bredehoff said, okay, I need to have a copy. Ms. Vasquez, may I approach, Your Honor? The court, yes, ma'am. Thank you. Your Honor, with permission, may we please play? I think just play the video, not like play in court. The court, can we just get that page to make sure everybody's at? Could you say the page number again, please? Ms. Vasquez, absolutely. Ms. Bredehoff, may I have the page? Ms. Bredehoff, page 372, line 5. 377, line 1 is what I have. Ms. Vasquez said 12, line 12. The court, all right, 372. Ms. Bredehoff, if we could just have a moment, Your Honor, to read it before it's played. The court, okay. Ms. Bredehoff, I still don't think it's impeachment, Your Honor.
I still don't think it's an impeachment, Your Honor, after reading it.
I'll overrule objection.
Well,
Thank
that's
you.
fine. You
Thank
don't have to think it
Your Honor.
is.
We can please have it published to the jury in the gallery.
The court, I'll overrule the objection. Go ahead. Thank you, Your Honor. If we could please just have it published to the jury and the gallery. The court, all right, whereupon the following audio is played.
The next thing that I'm going to play to you
Audio or video?
as cue.
Video.
Listen to this, please. Housekeeping.
Well, the internet will be happy about this.
Your Honor, maybe we stop that.
Oh no, why are we approaching? I tried to close the door 3 times. Ms. Bredehoff, Your Honor, may we stop that for a moment? May we approach?
They can do it through reading the deposition, Your Honor. They don't need to do that.
They don't need to do that. Yes, they do. And you haven't objected to the video before. You're objecting to the video because it looks bad. She should have let it finish, but she's not going to do that. So now we're at the next sidebar. The court, yes. Ms. Bredehoff, I object to them playing it. They've got the transcript on there. That's not appropriate. If they want to play the video deposition, that's one thing. But Ms. Vasquez said, all right, I'll talk to them about it. The court said, yeah. Ms. Bredehoff, they can do it through reading the deposition, Your Honor. They don't need to do that. I asked them to take it off the screen. So Ms. Bredehoff is saying that the transcript is on the screen with the video, and she's asking them to take the transcript off the screen with the video. Ms. Vasquez said, Your Honor, we're just going to put something over it. The court said, okay, that's fine. Ms. Bredehoff, I have no objection. Ms. Vasquez, can we please start it over?
That's fine.
Thank you.
I have no objection.
Can we please start it over?
Whereupon the following audio was heard.
The next thing that I'm going to play to you as
Say one.
cue. Would you listen to this, please? Housekeeping.
Wow. Yeah, they did. They covered the transcript. You're right. It was rolling down here. That's fine. Kind of a silly thing to argue over. She's not eating in court. She's eating in deposition, not in court.
I did not mean to do that. I did not do anything to. I did not kick at the door or push the door so that it would hit you. I did not. I swear. I mean, that was not my intention. I think I remember when the door scraped my toes.
Okay. So you told him in that excerpt that you hit him with the door but did not intend to hit him, correct? Did you say that?
I said whatever I said in that recording. I
Okay.
don't.
I said whatever I said.
For me to remember everything.
And that's a recording marked as exhibit the punching.
Q. That we just
Q.
played.
Q. Would you continue to listen to exhibit Q?
Are these from the same day?
I reacted.
This is going to be a long bit of cross right now. We're going to get into all of this deposition, I imagine. And then the stairway incident. But they're showing her disinterested. Wow. And eating.
I might have said, like, what the fuck? You know, whatever. That just been in the head with fucking water in the door.
I'm so sorry.
So this is impeaching that she responded to this audio, the same audio that was just played in court. She responded differently at the deposition.
I remember hitting you as a response to the door thing.
So that's what's going on right now.
That's exactly what I just told us.
And she's not even listening. She's joking with her attorneys.
Sorry about hitting you with the door. Hitting his head did not lead to nor.
You didn't need to hit me in the head with the door, but you meant to punch me in the jaw.
I meant to hit you. And
She doesn't think this is a big deal.
I did not do this thing with the door. I do remember. I did need to hit you.
So that you didn't mean.
Well, if we're eating, I'm eating too.
No, God, no. I
haven't had lunch yet either, Amber.
Okay, I'm sorry.
Oh,
So on the tape,
That-
you tell Johnny Depp that you did mean to hit him.
And it also misrepresents that what actually happened, which is him trying to get into a room I'm trying to keep him out of. And then he runs the door over my toes, trying to get into the room. I tried to push him out of it, which is what the hit is referred to. And Johnny, whenever he was injured or touched it, always referred to it in these ways of punching or clocked or whatever. And whether you discussed it with him or not, the last thing you do in talking to him afterwards or trying to reconcile with him is to get into what the definition of those words mean to him. I never even addressed it. If he was ever pushed, it was a quote. He called it a cold clock. I mean, it's just very dramatic.
Isn't it true?
Heard you testified
Wow.
yesterday that all you want to do is move on. Do you
Mhm.
remember that testimony?
Yes, I do.
Yeah,
You've
your exact
already-
words were,
you've already
quote,
brought it up,
I just
Camille.
want him to leave me alone. I want to move on with my life and he won't let me. Do you remember that?
Yes, that is correct.
But that's not true, is it, Ms. Heard?
oh boy.
It is very true.
What did she
You
do
just
now?
haven't been able to move on with your life, have you? From Mr. Depp.
I'm here, aren't I?
In fact,
That's
on
a fair
October
answer.
11th, 2018, you actually commenced an
Yeah, she has some
arbitration
good
action
answers.
against Mr. Depp for defamation, didn't you?
I don't recall that. No.
Your Honor, may I approach? May we approach?
There's another defamation case? Wait, what? Is she talking about the counterclaim? Is she not talking about the counterclaim? I have questions. Ms. Vasquez, Your Honor, may I approach? May we approach the court? Yes. Okay. So this is getting back into the questioning that they had talked about at Sidebar earlier. And then it's now just getting worked into the cross-examination at Sidebar. Ms. Vasquez, now that she said that she doesn't recall, I think I have to show it to her to refresh her recollection. I'm not going to publish it to the jury. Ms. Breda Hoft, I would have to say, Your Honor, in the deposition, she didn't have any recollection of this either. The court, she's entitled to see if it refreshes her recollection. That's it. You just have to show it to her and say, does this refresh your recollection? Okay, Ms. Vasquez said, thank you. The court said, you were supposed to read it. Are you done reading?
And if you can also read to yourself the second page of Exhibit 219.
It's not my understanding I initiated an arbitration. It's my understanding that our lawyers sent a letter to his lawyers after he called me a liar again, effectively, in an interview.
And that's 2 months before your op-ed that was published in December of 2018, right?
That is correct.
And that's 6 months before Mr. Depp filed this case against you, correct?
That's correct.
So you fired the first shot, not Mr. Depp.
I disagree. We sent a letter.
You knew the media had been alerted that you were filing for divorce, right, Ms. Heard?
No, I just knew that it was impossible to do that privately. So you could just hope it was a matter of time. when
You knew
filed.
they were going to be there, didn't you?
No, I did not.
Your
I mean,
publicist-
I assume since it's a public building that there is that likelihood, or not likelihood, but possibility.
They don't just
But,
camp out there. I worked there. There
I
are
was,
just
you know,
paparazzi there
I
every
was-
day.
I was shocked.
If we could please pull up page 74, lines 22.
You said
through
874?
74,
74.
line 22 through 75, line 13.
Why are they approaching again? But they are approaching again. We've had a lot of approaches today. Sidebar, I don't see this. The court said this is a text message sent to Jerry Judge. Ms. Vasquez says, she goes on, and at the very end of her answer, you see that she testifies she alerted TMZ about the divorce. TMZ was alerted at the very end of her answer. The court said, okay. Ms. Bredehoff said, I'm sorry, where is it? The court said, right there. Ms. Bredehoff, I'm not finding TMZ. Ms. Vasquez, it's at the very end of her answer. I'm sorry, I don't have my copy here. I don't have it with me, Ms. Bredehoff, to cite. I read the site. Ms. Bredehoff, I'm not seeing TMZ. The court, it says there, some of the blank TMZ, which was alerted. Ms. Bredehoff, it doesn't say she alerted them. In fact, she testified that Laura Wasser alerted them. The court, it is subject to direct other redirect. Her theory is that she stated it. Ms. Bredehoff said, well, I don't think it's impeachment, Your Honor. And the court said, yes. And Ms. Bredehoff said, it's just going to be the video deposition again. And Ms. Vasquez said, yes, thank you.
If we could please play and display to the jury Plaintiff's Exhibit 1280.
Ms. Vasquez, if we could please play it.
Did you send a text message to Jerry Judge on May 24, 2016, telling Jerry Judge, quote, I'm desperately trying to reach Johnny. It's extremely important. Please tell him.
I remember sending the text message that is in front of me right now to Jerry. And I remember sending this because I wanted to tell Johnny or have him told by Jerry or someone who knew him or was close to him. Basically, I didn't want him to find out online that I had or was about to file or I had already filed for divorce. I wanted him to know verbally. So I was trying to reach him through a third party to tell him. When I say reach, I'm specifically saying I would like him to know information coming from me or coming from Jerry from me so that he finds out about the divorce filing or my intention to do so from some other source other than TMZ, which was alerted.
Oh, fuck.
You slipped up there, didn't you, Miss Heard?
This was probably my favorite part of cross-examination because I had no idea.
You let it slip out that TMZ had been alerted to your filing of the domestic violence restraining order, didn't you?
I disagree. That's not what I'm talking about.
TMZ is the same outlet that you released the video of Mr. Depp attacking the kitchen cabinets the day before this deposition was taken, wasn't it?
I didn't do that. I don't know
TMZ
how
owns
to do
the
that.
copyright to that video now, doesn't it?
I have no idea
Yes,
what TMZ
Did they
owns.
pay you for that?
I never got paid for it because I had nothing to do with that.
So TMZ was just lucky in getting the inside scoop to your divorce from Mr. Depp, huh?
I have no idea. That's not my area of expertise. I wouldn't even know how to do that. And also, what does that get me? If I wanted to leak things about Johnny,
Let it
I
go.
could have done that in a
Let her
much
go.
more
Let her go.
successful way, in a bigger way,
Let her go.
for years.
Not
and
when you were
years.
extorting him for $7 million.
I got a fraction of what I was entitled to in the state of California, by the way. What extortion?
Tassa Van Ree is your ex-wife, right?
That's right. She's my ex-partner.
She's the one that you told this jury Mr. Depp was jealous of, right?
Yeah, well, that was 2013 fights around March, yes.
You testified that he tried to burn one of her paintings, right?
That's correct.
You testified he tried to burn one of your favorite paintings that she did, right?
I don't know if it was one of my favorites.
You testified he tried to burn one of your favorite paintings that she did, right? I don't know if it was one of my favorites.
You committed domestic violence against Miss Van Ree during your relationship, didn't you?
No, I did not.
You assaulted her at a Seattle airport in 2009, didn't you?
No, I did not.
What?
And people saw that.
That's not true.
And it was covered in the press. Isn't that true?
It was planted in the press by Johnny's team 2 days after I got the TRO. Not
Can
coincidentally.
you please pull up Plaintiff's Exhibit 1279?
No, she did not.
Your Honor, may we approach?
Your Honor, may we approach? Ms. Bredehoff, Your Honor did not permit her to go into that. This is regarding the DV with her previous partner. The court, we said you could get into those, the articles themselves. Ms. Vasquez, the only article I plan to show is this one. It doesn't have the word in here. The court doesn't have the word is not going into evidence. Ms. Vasquez not going into evidence. Ms. Bredehoff not going to be shown to the jury. The court not going to be shown to the jury. Ms. Bredehoff, okay, thank you.
You could please have that article displayed for the witness.
Oh,
This is an article from 2
no.
years ago, correct, Ms. Heard?
I don't know when this
May of
was.
2020.
That's not when it came out, no.
Amber's trying to move this way. And Camille's like, what? I'm just staying the course. Amber's going to answer however Amber's going to answer. And Camille's like, we're just staying the course and asking the questions. And at this point, Camille's like, it doesn't even matter what Amber says. She's just going to stay the course in her cross-examination and not get sidetracked down, chasing down these rabbit holes.
This story started getting planted in after I got a TRO.
There's no question
after I got a
pending.
restraining order against Johnny.
There's no question pending.
The headline says Amber Heard
Objection,
allegedly
Your Honor.
struck.
Objection, Your Honor. I think Your Honor ruled she can't say that.
If you want to approach again.
That's obviously not what the court ruled. Otherwise, the court would have reminded Camille that she can't say that. At least Elaine found her microphone button. Ms. Bredehoff, objection, Your Honor. Objection, Your Honor. Your Honor ruled she can't say that. I forgot about that. The court, if you want to approach again, sidebar. It was just the title, the court said. Ms. Vasquez, just the title. The court, the title, can't have the rest. Ms. Vasquez, right, doesn't have the word. The court, okay.
The title reads Amber Heard allegedly grabbed,
She won.
struck her ex-girlfriend at the airport.
She won.
Doesn't it?
Yes, and that's not true.
Oh, dear.
May we approach?
Okay.
She's opened the door. She's opened the door. The door is fucking open. You Vasquez, may we approach? Okay. Sidebar. Your Honor, I think she's opened the door to the arrest. I mean, the fact that she's saying that that's not true, that she grabbed and assaulted her ex-girlfriend, yet she was arrested for the exact thing, I think at a minimum, it should be allowed to show her the arrest record. Again, I'm not going to be admitting it to see if that refreshes her recollection. And in fact, she did assault and grab her girlfriend. The court, she did say no. I think this opens the door too. I agree with that. Ms. Bredehoff, no, Your Honor, I'm sorry. What did Your Honor say? Oh boy, Ms. Bredehoff, right, because she's still going to deny, and that's the whole point. The arrest is not a conviction. She's the court, I'm not going to allow that. Ms. Vasquez, thank you. Ms. Bredehoff, you're going to? The court said, no, I'm not. And that's why they brought in the witness instead of the fact of the arrest. Ms. Bredehoff said, okay, thanks. I couldn't hear you. The court said, I just don't know if I was, sustaining your objection or overruling her. I wasn't sure exactly which way we were. Ms. Bredehoff said, thank you. Thank you. Ms. Vasquez, so the article title is Amber Heard allegedly struck her ex-girlfriend. Ms. Bredehoff, objection, Your Honor. She's already, the court overruled. The door has been opened. We will see what happens. Oh, well,
So the article,
you're going
the
to make us
title
prove
is
it.
Amber Heard allegedly struck her
Objection, Your Honor.
ex-girlfriend.
She's already
Overruled. Go.
Thank you. If I may start over.
Yes, start over, Camille. You
Amber
go off,
Heard
girl.
allegedly struck her ex-girlfriend, Tassa Van Ree, at the airport in 2009. Did I read that right?
Yes, this is another example of the smear campaign.
So Mr. Depp is not the only domestic partner you've assaulted, is he, Ms. Heard?
I've never assaulted Mr. Depp or anyone else that I've been romantically linked to, ever.
Sure.
No further questions.
No
Your Honor.
further questions.
Cross-examination. I'm sorry, redirect.
That was
Ms. Heard,
masterful.
Did Ms. Van Ray come out after that article came in and make a public statement
Hearsay.
it was false?
Of course I did.
Objection, Your Honor.
Hearsay,
Hearsay.
move to strike.
Your Honor, I should at least be overruled.
No.
Thank you.
Of course she did.
You were asked by Ms. Vasquez about
Vasquez.
why Mr. Depp
Not Vasquez.
won't or can't look you in the eye. And she read out, or she played a tape in which Mr. Depp said, "You will not see my eyes again." Do you recall that?
She
And that was
did
during the
not.
mediation process in July, correct?
That was
Objection leading.
the first one.
Sustained
Okay.
is leading.
When was this?
That was in July of 2016. That was the first mediation
she
attempt.
just
We met
mocked-
after that, and Johnny very much looked me in the eye.
That was in July 2016. It was the first mediation attempt. We met after that, and Johnny very much looked me in the eye. Please tell the jury about the next meeting after he said, "You will not see my eyes again." Is this when she was mocking him? When she was like, "You will never see my eyes again."
You will not see my eyes again.
Do you remember that? I was so appalled that Elaine was doing that when she was mocking his testimony.
Please tell the jury about the next meeting after he said, "You will not see my eyes again."
You'll never see my eyes again.
We met in the lawyer's office. They gave us a moment. Johnny kissed me again, held me. I cried, he cried, and then we had a short exchange, and he put a note in my pocket that said, "I'll love you dead or alive, my Slim," with his new phone number on it.
I'd like to bring up, Michelle, if you can, Defendant's Exhibit 1581L.
She mocked him. She mocked him. Elaine.
Do you recognize this?
I did
Objection,
not.
Your Honor.
I did not have any of this on my.
Yes, ma'am.
Objection, Your Honor. May we approach? Yes, ma'am. Sidebar. Ms. Vasquez. So we are now in redirect. Correct. She's clarifying because this is no longer cross-examination. So we are now in redirect. Ms. Vasquez, this is something that was never produced. And if it was produced part of a late production and past discovery cutoff. Ms. Britta Hoff, so it was produced by Mr. Depp. It was used in the UK trial. Mr. Depp produced it as a black and white in this case. This came out in color. It's true, though, through Mr. Young's view, but it's not responsive to any document requests that they've asked for. The court, I'm going to sustain the objection. So whatever they were trying to bring in was a, oh no.
To be, just so we're clear, on
Asked
how
and
many
answered.
occasions in that second mediation did Mr. Depp look you in the eye?
Many.
Okay. And when Ms. Vasquez asked you if you knew why Mr. Depp couldn't or wouldn't look you in the eye here or in the UK, you said, yes, you know. Why? Please tell the jury why.
Because he's guilty.
What's with the sappy face?
He knows he's lying. Otherwise, why can't he look at me?
It's a whole different tone.
It has been suggested by Ms.
we're gonna go right in a minute.
Vasquez to you in your questions that you didn't tell anyone about the abuse until the TRO. Is that true?
Objection, Your Honor. Leading.
All right. What if any? All right.
What if any?
Who did you tell about the abuse during the time it was happening?
Calls for
Objection, Your
hearsay.
Honor. Leading.
That's not offered to
Calls for
and
hearsay. Hey,
Your
Elaine.
Honor, it's prior
Elaine.
consistent statements.
It's leading. It's
Elaine.
sustained. Next question.
Okay.
Elaine.
What, if anything, did you tell to anyone about the abuse?
Objection, Your Honor.
therapist.
Hearsay.
I'll sustain.
Your
Get
Honor,
it, Camille.
Your Honor, may I approach?
That's fine.
May I approach? I'm going to tell you how it's not hearsay, and the judge is still going to say that it's hearsay. The court, that's fine. Sidebar. You don't have forever to do that. I mean, there has to be a timeline you're talking about. You can't just be like, when and always, right? Actually, Your Honor, there's two different ways I think it comes in on prior consistent statements. Your Honor, I submitted a brief earlier to the court, Your Honor. The court, I've seen it, Ms. Bredehoff. So there are two parts to this. One part is just the prior consistent statements on specifics. And I will have some of that. But the second is the offer to rebuff allegations of recent fabrication before litigation arose. Oh, she's reading something. She's definitely reading down the line. But the second is offer to rebuff allegations of recent fabrication before litigation arose. Well, that's not recent. This litigation arose a fucking million years ago. And the Virginia Supreme Court has further defined this principle, and I'm citing Faison here, where a witness has been assailed on the ground that the story is a recent fabrication or that they have had some motive to testify falsely, proof that they gave a similar account of the transaction when the motive did not exist before the effect of such an account can be foreseen or motives of interest would have been induced. A different statement is admissible, and that's the case. In this instance, they're clearly suggesting that she's made this up for the TRO and that it was never there before. She didn't tell anybody. It didn't exist. And I think that brings in, Ms. Vasquez says, that's not what we're saying. Ms. Bredehoff said, all of the statements, Your Honor. The court also sustained the objection. Ms. Bredehoff, Your Honor, just so I make a complete record on that, I'm removing the admission of the exhibit, and I tried to put in the last Wednesday and Thursday that were for hearsay because they're prior consistent statements. That doesn't get you. I just want to put on the record, Your Honor, the court said, okay, that's fine, but it's not prior consistent statements, so I'll sustain the objection.
Ms. Heard, how many people have you shared the fact of abuse prior to 2015?
Objection outside the scope of cross. Outside the scope.
hearsay.
Outside the scope.
Overruled.
Outside the scope of cross.
Roughly about 10.
Are they all coming into court?
Can you name them?
Objection, Your Honor.
Relevance.
Hearsay.
Relevance.
I think she can. It's not offered. It's just showed that she had.
Stop.
She informed people.
Arguing.
Objection, Your Honor. Can we approach?
This is preposterous, Elaine. Ms. Vasquez, objection, Your Honor. Can we approach? This is, again, at this point, I remember this very well. All of this. Your Honor, she's making arguments in front of the jury. The court, I understand. Ms. Vasquez, and it's just inappropriate. It is. I mean, you said at the outset of the trial, speaking objections are not to be permitted, just one word objections, legal objections. The court said, okay, so, and Ms. Bredehoff said, so, Your Honor, I think it's been suggested that she made these up. I think she should be at least, the court said, right. She said 10 people. So why do we need the names of the people? Ms. Bredehoff said, okay. The court said, I'll sustain the objection. Thank you. Back to open court. Preposterous.
You were asked.
And again, moved on.
Whether you had consulted a medical doctor about any problems with your nose,
She's
correct?
magical.
That's correct.
And you indicated that you in fact had after the divorce.
Objection,
correct?
leading.
It's leading as fuck.
Did you or did you not consult an ENT after
How many
the divorce?
objections were there?
Objection, leading.
Did you produce medical records to the defendants relating to this?
Calls for legal
Objection,
conclusion.
leading. Calls.
I'll sustain the objection.
Thank you.
Leading. Next question.
Your Honor, if we
Can you
could-
please
witness
admonish
could be
counsel?
instructed not to answer until I've
All right.
lodged my objection.
Wait for the objection, please.
Could we bring up defendant's exhibit?
Your Honor, could you please admonish
1077?
counsel to ask better questions? Could you just remind her that this is a
Do
trial?
you recognize this document?
My screen is black.
Oh, sorry.
Yes, I do.
And could you tell us what it is?
I forgot to take notes. I don't know what's happening.
What my ENT, the ears, nose, and throat doctor, told me was.
Objection, Your Honor.
calls for
Hearsay.
hearsay.
All right,
Stop talking.
When there's objection, please stop talking. Thank you. All right, I'll sustain the objection as to hearsay.
Okay.
Stop trying to get into more.
I'm
I don't like this style. And Elaine's getting into the style she gets into in Cross, where she's trying to just squeak stuff in.
What, if any, you were asked if you had, it was suggested that you had not produced this in discovery. Is that true?
Objection, Your Honor. Leading.
Your Honor, she absolutely did that.
It's leading. It is leading question. though.
Stop it, Elaine.
Just leading.
What, if anything, did you do to produce medical records to the defendant, to the plaintiff in this case?
I turned over all of my devices and they had
No, you didn't.
Johnny's team had a third party or someone they selected as a third party go and pull all relevant documents from those devices, which I handed over.
Do you know how many were handed over?
Hundreds of thousands, I believe. Maybe.
Objection, Your Honor. Lack of foundation.
All right, I'll sustain the objection. Next question.
She didn't
And
do any
do
of
you,
that.
what, if anything, did you produce to the plaintiff in connection with your consultation with an
I'm
ENT
surprised they're getting into
specialist
this.
relating to your
I'm surprised they're
nose?
trying to get into
Objection,
this.
leading.
Sustain.
This is a mess.
Foundation, hearsay.
What if anything? It's not the cure-all. It's sustained.
Yes, Your Honor, yes! Finally! Say what we've all been thinking, Judge A. Get it. What, if anything, is not the cure-all?
When did you
Boss.
see an ENT specialist?
2017.
Judge A is over it.
2016 or 17.
You're not going to make fetch happen on this one, babe. Stop. Girl, just stop. Just stop. Take a breath. Move on.
What, if any, production did you make to the
This is a
plaintiffs
mess.
of
And the
your
jury's gonna
medical
see it's a mess.
records with the ENT?
Objection, Your Honor, lack of foundation.
This is a mess. Move on.
If you only a foundation.
Did you see
Do you
Rottenborn?
know
Not Rottenborn.
whether
Sorry, Chew.
the records, medical records
No.
from your EMT were produced in discovery? in this
Objection,
case?
Your Honor, lack of foundation calls for speculation.
I'm asking.
Overruled if she knows.
I'm just trying to get this evidence in.
And do you recall?
This does not help them the way they think it does.
I'm trying.
We got that. We got that.
What, if anything,
Nope.
did the medical records reflect about
Nope.
your nose?
Calls
Objection,
for
Your Honor,
hearsay,
hearsay.
medical
Sustained
conclusion. Calls for expert testimony. Move the
Do you
fuck
have
on.
injuries to your nose?
Yes,
Please describe those to the jury.
Now?
I have
I'm going to
a bunch of
object.
scar
Objection.
tissue.
I'm going to object to the extent it calls for hearsay
And it calls for a medical
and lack of
conclusion.
foundation.
Overruled.
You certainly testified to.
No, she can't.
We'll see where it goes. Go ahead.
Okay.
No, she
Go
can't.
ahead.
You have to bring in doctors to
I
prove
have
bones are
a
broken.
significant amount of scar tissue in my nose.
Objection, Your Honor.
I'll sustain the objection.
That's and strike it.
What, if any, difficulty do you have breathing?
Move on.
Objection, leading.
What, if anything? And that does cure a
No,
man.
it doesn't.
No,
But
it doesn't.
I'll overrule the objection.
Thank you. Do you remember the question?
I have a significant amount of trouble breathing at night, and I've been putting off having surgery for it.
Which could be caused from a number of things. Are we done? Are we moving on from this? This was abysmal, and this did not help.
Now, you were asked
You might
about
be
December
embarrassed.
15, 2015.
DUI guy has died of
And
secondhand
Ms. Vasquez
embarrassment.
suggested that you did not report the abuse or the injuries to Aaron Falati. Do you recall that
Objection, Your
question?
Honor, leading.
Your Honor, I'm
Sustained.
entitled to go into what Ms. Vasquez
It's,
asked.
the objection is leading. I'll sustain.
But
the
you're
objection.
not entitled to lead, Elaine. You need to ask
Did you report?
open-ended questions. You're still
What, if
leading.
anything, did you report to Aaron Falati about the abuse you sustained
I'm
on
angry.
12/15/2015?
Objection, leading and
You're-
hearsay.
Approach.
The judge is going to rip into Elaine because this is wasting court time. It is unprofessional. And the judge, there is no way this judge isn't going to look at Elaine and be like, what the fuck are you doing? The court objection is to leading. I'll sustain the objection. Oh, Ms. Bredehoff. Okay, did you report? What, if anything, did you report? Objection, leading, and hearsay. The court approach. The court is just like, come on. The court approach. Sidebar. The court. You can't just put what, if any. You can't just put what, if any. Miss Bredehoff, I can't hear you. I think at this point, Miss Bredehoff's like, I don't want to hear you. The court. You can't put what, if any, in front of a whole statement and say you're directing her directly to that. There are ways to ask the question. You just can't ask it in those ways. Ms. Bredehoff, so if I'm going to, Your Honor, I would like to do a preview. The court said, sure. Ms. Bredehoff, there is notes from Aaron Falati's records that were excluded from 1216. Yeah, excluded. The court, okay. Ms. Vasquez read from 1217. The court said, okay. Ms. Bredehoff said, I'm going to now bring in 1216 prior consistent statement because she was impeached with 1217 from the hotel about injuries. In fact, Aaron Falati documented the day before that client states JD was inebriated, client states disagreement escalated, and states husband abuse to head, client denies loss of consciousness, headache, and closed eye. I would encourage client to notify Dr. Kipper and then go to emergency room. Client declines, states friend Rocky is here and that husband will not be able to enter home. This is a direct response to, this is a prior consistent statement. Your Honor, Ms. Vasquez asked her about 1217, which is in evidence. The court said, right. Ms. Bredehoff said, and suggested that she didn't tell her about it, that she went and got that Dr. Kipper wrote and suggested that she didn't tell him about the incident. So she's suggesting she falsified the incident. This is a prior consistent statement to Nurse Filati. So I'm going to, Ms. Vasquez said, Your Honor, it's hearsay. The court said, well, she's saying she's not using it. She says, exception to hearsay, it's prior consistent statement. Ms. Bredehoff said, correct. Ms. Vasquez said, but it's still double hearsay, Your Honor, because it's not Ms. Heard's statement. It's Ms. Heard's statement allegedly to a nurse, and it's recorded on a document. That's double hearsay. That's still double hearsay. The nurse isn't testifying to that. Ms. Bredehoff said, that's the whole point of having an exception to hearsay. Ms. Vasquez, no, you still can't get over. The court said, I understand. I see what you're saying. Ms. Vasquez said, and you need an exception. Ms. Bredehoff said, and there's a medical records exception. Ms. Vasquez, no, there isn't. Okay, different. There is there are exceptions with regard to records, but this is not that circumstance. Jesus Christ, this is wild. No, there isn't. The court, who is CT? Ms. Bredehoff, client. The court, client. Okay. Ms. Vasquez, by the way, my question wasn't, what injuries did you tell Aaron Filati about? Which would have elicited that testimony, perhaps. But you still have to get over the 2 levels of hearsay. She doesn't have an exception for the 2 levels of hearsay or the 2 layers of hearsay. Ms. Bredehoff said, I don't agree. A prior inconsistent statement is an exception to the hearsay rule, and so is the medical record. The court said, but medical record, you still have to get over the hearsay in the medical record. Ms. Vasquez, you have to get over the hearsay. Shh, Camille, at this point, shh. Ms. Bredehoff, it's not hearsay. The court, anyways, where we're at, Ms. Vasquez, correct. She's trying to offer it. Ms. Bredehoff said it's specifically intended to impeach her and suggest that she did not tell Aaron Filati about the injury, and she brought up the 1217 note, which is an evidence. Ms. Vasquez, I did not. The court, all right, this is what I'm going to do. I'm not going to allow this into evidence because it's double hearsay, but because I'm not going to allow this into evidence because it is double hearsay, but because it is a prior consistent statement. If you want to ask her, did you tell on 1216, did you tell the nurse about your injuries? I'm going to allow it because that would be a prior consistent statement, but I'm not going to allow the notes in. Does that make sense, Ms. Bredehoff? It's just, I know the jury doesn't get to see that, and they see the 1217 and they're misled. The court said, but you have a hearsay issue inside of that. I'm not allowing you to ask the question for prior inconsistent statement because I think that's appropriate. Ms. Vasquez said, just what? And not reading in. The court said, and not reading in the note, just an open-ended question. What did you ask her? Ms. Bredehoff said, then I also have the text message exchanges between Aaron and Amber Heard on 1216 about this. Defendant's Exhibit 535. Oh, my mouse just stopped working. That's not helpful. Your Honor, and for the record, I want to move in plaintiff's 46A to add in the 1216-15. Which part are you saying is a prior consistent statement? Bredehoff, she's telling her about the headache and goes through, and then she finds her, I think the 3rd page, Your Honor, is the exception. Show me the prior consistent statement. Ms. Vasquez, Your Honor, I'm going to just object. None of this should be omitted. The court, well, the prior consistent statement, Ms. Vasquez said prior. The court said, go ahead. Prior consistent statements cannot be admitted into evidence because they're used to rehabilitate the witness. The court said, right. And Ms. Vasquez said, but it cannot be admitted into evidence. The court said, right. So you can ask her the question, but I'm not going to allow the documents. Ms. Vasquez said they have to be open-ended and they can't be quoting. It's hearsay. The court said you can't quote the text. And this is the problem, is that Elaine wouldn't not quote the text. And that's where this back and forth went far afield. So now they're talking about what questions they're going to ask.
And did you text with Nurse Filati on 12/16/2015 about the injuries that you had suffered as a result of Mr. Depp's attack on you on 12/15?
Yes, she guided me through a concussion check.
You don't do a concussion check over the phone, by the way? I mean, I know my EMT training was a long time ago, but for real, for real.
Cowan about the injuries you sustained.
Objection, Your Honor. Hearsay.
Yep.
It's prior consistent statements.
It doesn't
I'm going to sustain the
matter.
objection at this point. Next question.
Do you recall Dr. Laurel Anderson testifying that she saw two
She's not
black
gonna get
eyes?
into it.
Objection, Your Honor, leading.
You're not going to get into a lot of these
Sustain
prior
is leading.
consistent statements, Elaine.
What, if anything, do you recall from Laurel Anderson's testimony in this case about what she
Objection, that
observed
calls for improper
on
evidence.
12/17/2015?
And it's leading.
Objection, Your Honor. This is outside the scope of
It's
cross-examination.
well outside the
Prior
scope.
consistent statements.
You're not allowed to just get into any prior
Observations
consistent.
for the
I'm gonna-
12/17, the same day.
Sustain the objection. Next question.
May I approach?
Okay.
No, why are we approaching? The judge has ruled, Elaine. May I approach? Sidebar. We are now on sidebar, I think, 26. Ms. Vasquez, the court said prior consistent statements can't be testimony that's in evidence. That's not how it works. Ms. Bretterhoff, they brought in Dr. Kipper's notes from 12/17 alleging that she didn't say anything about it. And 12/17, she's appearing in front of Dr. Anderson. The court, again, prior consistent statements can be permitted when you're asking about testimony that's not her consistent statement. Ms. Bretterhoff, Ms. Vasquez got to talk about it. The court, that's not prior consistent statements, though. I'm going to sustain the objection. You can move on. You can feel the life draining from the judge. You can just feel it.
Backless dress.
Leading.
Objection, Your Honor.
And assumes facts not in
Leading.
evidence.
Calls for speculation.
Assumes facts not in
I'll
evidence.
sustain the objection.
Calls for speculation.
We've heard
Elaine is unpleasant. That's why I
testimony
call her
about
Umbridge.
Mr. Depp making a total of $65 million in 2015 and 2016 from his experts.
Objection, Your Honor.
Why did
Leading.
I haven't asked the question.
Hearsay.
Why did you not ask for $32.5 million from Mr. Depp?
Objection
Your Honor.
assumes facts not in evidence.
Leading.
And leading.
I said, why did you not ask?
Irrelevant.
I'll sustain the
Explanation.
objection. Sustain the objection to leading. Next question.
Elaine?
Why, can I just ask, why did you not ask for $32.5 million from Mr.
No,
Depp?
that's leading.
Because I don't
Assumes
Often
facts not in
answered.
evidence.
Relevance.
Assumes facts not in evidence.
Because I didn't want it. I realized that that's what I was entitled to, but I didn't want it.
You were entitled to 32 million. Were you really?
That's simple.
That assumes facts not in evidence, calls for legal conclusion, calls for expert testimony.
What, if any, role did Mr. Depp play in your getting Aquaman?
Calls for
He tried to
speculation.
have me fired from it.
Objection, Your Honor. Speculation.
All right, I'll sustain as speculation.
How do you know that he tried to have you fired?
Objection, Your Honor. Calls for speculation and hearsay and lack of foundation.
I'm trying to lay a
Well,
foundation.
you're not doing it well. Then lay
I
the
saw it.
foundation.
I saw the emails. I saw the texts.
I'll sustain the objection.
so
to
that's hearsay.
Next question.
Amber's, I
Please
feel
describe
bad
to
for
the jury your
Amber.
interaction with Isaac Baruch during the week of
I feel
May
bad for
22nd.
Amber.
Well, not only did I
'Cause her
have
lawyer's
makeup
not
on,
artfully
but I
doing
did
this.
attempt to kind of let him know what happened.
Objection, Your Honor. Hearsay.
I'll sustain the objection. Next question.
You were asked some questions about Officer Melissa Science's testimony. What, if anything, do you recall relating to Officer Melissa Science's testimony relating to your injuries?
Objection, Your Honor. Hearsay.
Your
All
Honor
of
said I could redirect after the cross-examination.
You can redirect, but you can't fucking lead. That is completely inappropriate, Elaine. What, if anything, do you recall relating to Officer Melissa Sainz' testimony relating to your injuries? Jesus Christ, what is that question? Objection, Your Honor, hearsay. Ms. Bretterhoff, Your Honor said I could redirect after cross-examination when the court, do you want to approach? The court, you can redirect, but not hearsay. I mean, you can hear the court being like, rules apply. Ms. Vasquez, hearsay and leading. Ms. Bretterhoff, Your Honor, it's patently not fair.
It's patently not fair for them to cross-examine and then Your Honor to say, that's for redirect. And I say, she answers these questions and she's answering what Melissa's saying. She's testifying to what this is Ms. Vasquez testifying to what these people testifying to and asking them questions. I object to that because I think that's not the proper way to do it. Your Honor says, that's for redirect. And now I'm trying to redirect. The court.
You still can't redirect on hearsay. You still can't redirect with hearsay. It's like, yes, you can redirect, But the rules of evidence still apply. The court, you still can't redirect with hearsay, Ms. Vasquez, or leading. Your Honor said I could redirect. You can redirect. It's redirect. Direct means you ask open-ended questions, not leading questions. Elaine, you can't lead. Your Honor said I could redirect. Who the fuck do you think you are in this courtroom right now? I'm not sure from that question exactly. I mean, are you trying to get to whether her testimony was when she testified? Because that's what she was talking about, was the testimony, the in-court statement she made for a deposition that was played as a witness. Is that what you're trying to get to, Ms. Bredehoff? Yes, the court. That's not what you asked, Ms. Bredehoff. Okay, all right, but it's not hearsay if it's an in-court statement, so I can ask that because the court said, you're talking about her testimony if she knows what her testimony was. Ms. Vasquez, but you still can't lead the witness. The court, but you still can't lead. Ms. Bredehoff, okay, thank you. Thank you. Open court. I am frustrated for Amber Heard in this moment because no matter what you think of her and think of her performance on the stand, she is entitled to an attorney that is not an embarrassment.
Do you recall of Officer Sines' testimony in this case relating to your injuries and the property destruction?
What, if anything, do you recall of Officer Sines' testimony in this case relating to your injuries and the property destruction?
She didn't feel that the state I was in was enough of an injury to her, or it wasn't injury seeming to her.
Can you describe for the jury what the interaction was?
Don't try to fix this. I would have let it go and moved on.
He, after seeing my face, put his head on my
calls for
shoulder.
speculation.
She doesn't call for speculation.
Yes, it does.
He sees her.
He touched the side of my face too.
Okay.
Again, Your Honor, if we can instruct the witness.
If you could wait till after the objection, please. All right, next question.
What did Mr. Franco do on the elevator before laying his head on your shoulder?
This isn't going to help you.
The side of my face and responded to what he saw.
How do you know he responded to what he saw? That's also speculative.
We talked about the
why someone else did something is pure speculation.
Newspaper headlines, and there was one in particular referring to sexual violence.
I wouldn't
what,
touch
if
this with
did
a
Mr.
fucking 10-foot pole.
To you relating to that article?
Objection, Your Honor.
Leading.
Lack of foundation, calls for speculation.
What did he do to her?
Unintelligible. I don't understand the question.
Overruled. We'll see where it goes.
He was carrying the paper that had that headline on it that he leaked and threw it at me.
She sustained the objections, Elaine.
Next question.
Yeah, okay.
Elaine was like, what?
I don't have any more questions, Your Honor.
All right.
Great.
Ma'am, you can have a seat next to your attorney.
Please
okay?
sit down. And with that, we are done with Amber Heard as a witness. Wow. I think she gave up and went home. She's like, yep, I'm done.
All right, ladies and gentlemen, let's go ahead and take our afternoon recess then for 15 minutes. Do not discuss the case with anybody and don't do any outside research, okay?
Oh, let's take a break. Oh, let's. Please, let's.